of Law, Volume 59 Law Review. We want to welcome all of you to our annual symposium, Navigating Boundaries, Legal Perspectives on Migration. We are very, very excited for a day of insightful and productive discussion with you all, and I'd like to start off the day by welcoming Eva Hoffman, Editor-in-Chief of Volume 59 of USF Law Review.
Welcome everyone. On behalf of the USF Law Review, it's my honor to welcome you to our 2025 Law Review Symposium, Navigating Boundaries, Legal Perspectives on Migration. First, I want to extend my gratitude to our distinguished speakers, panelists, faculty, and guests. Your presence here reflects a shared commitment to examining the most pressing legal issues of our time. I also want to recognize our symposium editor, Aram Manukian, and the entire Volume 59 team for their hard work in organizing today's event. For nearly 60 years, the USF Law Review has provided a forum for legal scholarship that informs academia, policy, and practice. Our annual symposium is a cornerstone of that mission, bringing together scholars, practitioners, and thought leaders to engage with legal challenges that shape our society. Few issues are as urgent and scrutinized as today's topic. The legal frameworks governing immigration are being tested in real time by shifting immigration policies, humanitarian crises, and debates over national identity and security. Immigration law is not just an area of legal practice, it is at the heart of fundamental questions about rights, borders, and belonging. Today's discussions will examine how legal innovation and cross-disciplinary collaboration can help navigate these complexities and push toward a more just and functional system. It is not lost on me that the topics we are discussing today are having and will continue to have a profound and intimate effect on the lives of many in our community. For many of us, today is about so much more than legal theory or politics. If you are seeking resources to help community members learn more about their rights and how to prepare in case of emergencies, please visit our Law Review table. To open today's program, it's my privilege to introduce Professor Bill King. A leading scholar in immigration law, race relations, and social justice, Professor King is the co-founder of USF's Immigration and Deportation Defense Clinic, along with Professor Brown. His work, spanning litigation, policy, and advocacy, has shaped immigration law and continues to drive reform. His latest book, Humanizing Immigration: How to Transform Our Racist and Unjust System, challenges us to rethink the structures that govern immigration today. Please join me in welcoming Professor Bill King.
Morning, everyone. Thank you for joining us. It's really a privilege and an honor, and I'm happy to see all of you. What time is it? I guess we could call it after breakfast. My morning routine has changed a lot since a student in one of my classes told me and the rest of the class that she never listened to news until mid-morning, and that instead she would either listen to music or comedy. And I can't even listen to comedy anymore because the comedy also reminds me of what's happening in the news. So every morning it's music now, and I try not to, but people in this room know that this is not true. I try not to even open my email before breakfast, but because the email is flooded with all the evils of what's happening today. The practice of border externalization, think about that for a moment, has grown quite a lot in recent years. And that's a strategy by countries to control migration flows and immigration policy outside of their borders. It involves working, paying, or pressuring other countries or private entities to prevent migrants from reaching a country's borders. Of course, this often results in placing significant and unequal burdens on third countries, often states with fewer resources, and it often, of course, triggers human rights violations. Many countries engage in the practice of border externalization. Australia's policy, the so-called Pacific Solution, dates back decades. Multiple European Union practices, including that of establishing like regional protection areas near refugee-producing countries and codifying the safe third country concept, has occurred. Of course, the United States is a major proponent of border externalization. From the Reagan administration's interdiction on the high sea of Haitians fleeing persecution to the Obama administration's big payments to Mexico to keep desperate women and children from reaching the U.S. southern borders. And of course, Trump's various efforts to force migrants to apply for asylum in a country other than the United States, and the Biden administration's continuation of many of those policies. The United States may be regarded as the king of border externalization. Of course, the new Trump administration will compound border externalization policies to control migration to the United States. But given what we now know about states like Texas that has criminalized status and authorized state judges to deport migrants, his policy, Trump's policy, is one of what I call border internalization or border obliteration. It's a strategy that redefines boundaries between state and federal authority to allow states to join the federal immigration enforcement regime without much formality. The blessing of instruction is simple. Do as you please, and we will be back, and we'll back you up. So border obliteration is not destruction of borders in an abolitionist sense. It's an invitation to subnational jurisdictions to join the circus. The invitation of this lack of boundaries party is readily accepted far beyond the confines of Texas. At least 9 states have taken the cue from Texas and copycatted their way into the fold. States like Oklahoma, Iowa, Arizona Part 2. Iowa approved legislation criminalizing illegal entry, while Louisiana and Oklahoma now allow local law enforcement to enforce immigration laws. Oklahoma also has taken steps to require parents to provide schools proof of citizenship before their children can enroll. The state superintendent of public schools also announced this week that he would allow ICE agents into Oklahoma schools to enforce immigration laws. And lawmakers in Mississippi have proposed providing a $1,000 reward to bounty hunters to aid in the deportation of undocumented migrants. So border obliteration policies are not about bringing down borders between nation states. Border obliteration policies are about destroying distinctions between the boundaries of immigration enforcement between federal and local law. In the case of inviting residents to report on their neighbors and coworkers, destroying distinctions between law enforcement and public is inviting vigilantism. Given all the days around IRCA in 1986, and many in the room were not born yet, back then, lawmakers felt that they only had 2 choices: do nothing or grant legalization, because they felt that a massive deportation program was not practical. Truth be told, a massive deportation program is still impractical. But today, recruiting or condoning state immigration action and using whatever federal sources, their resources that can be mustered to implement and facilitate deportation, no matter how relatively ineffective that they may be in the scheme of things, it's sufficient to instill widespread fear. In the process, we'll be left with a dystopian state, and just look at Texas and you'll see what can happen in the rest of the country, with folks worried wondering what will happen to their children if the parents are deported, needing to have family preparedness plans in place, afraid to send their children to school, afraid to go to work. Since the election, Jacqueline Brown and I have conducted at least 10 immigration consultation events throughout Northern California. And what we see is something that I read more than a year ago about Texas. There was a report in Texas about parents wondering, do we need to leave? Is it safe for us to stay? Do we have our children's passports? What if I get picked up on my way to work, and who's going to pick up my kids from school? Well, those are the exact same questions that we hear from a large portion of the folks that we have now consulted with since the election. The good news is that there are random acts of resistance. Many in this room are part of those actions. Just this week, I talked with pediatricians from County Hospital. I talked to school teachers, elementary and high school, counselors, ministers, Catholic priests, who are all part of the resistance of action, resistance to these actions. Last night, I spoke with a school counselor about students who were afraid to go to their driver's ed class and they had all these questions about AB 60 driver's licenses, which incidentally we still recommend that they get them. It's not evidence that you're undocumented, and carry them with them. But it's not just our allies. The migrants themselves are leading resistance with students like the ones that I spoke to last night. I've even had former clients who volunteered for the weekend consultations. And the same parents who were concerned about whether or not they need this or that for the family preparedness plan, they have agreed to be joyful. Because joyfulness is an act that our paralegal, Vanessa Cerda, at the clinic has reminded us, is an act of resistance as well. At this time, I'd like to invite my colleague at the law school, Professor Harris, who's the director of the Human Rights Clinic, who's going to coordinate the first two panels. Professor Harris.
Okay. Good morning, everyone. It's incredibly intimidating to be up here and follow Professor Hing, but also because of all the suits in the room. It's a little bit men in black, and I just haven't been in that many suited environments lately, so I came in and was like, oh, okay. But we're all friends here. It's really an honor to be with you all today in community, gathering in such a challenging time as we kind of brace ourselves, and strengthen our resolve and connections to one another for all that lies ahead. So I have the honor of introducing our first panel. Panel 1 is entitled Expanding Access, Reimagining Legal Support for Vulnerable Immigrants. And I am going to be joined by 3 incredible advocates and colleagues on the stage today. So maybe after I read their bio, you can come up and join me. Feels a little bit like a game show. So I'm first joined by Professor Jacqueline Brown, who is an associate professor and director of the Immigration and Deportation Defense Clinic, which Professor Hing has alluded to. How many folks do I have in the room who have taken the clinic, are in the clinic right now? Can you show of hands? Okay, can we get like a little bit of applause for our amazing So a little bit more about Professor Brown though. She actually began her career in 2005 in the San Francisco Immigration Court as an attorney advisor through the DOJ Honors Program. And then she launched her own private practice in 2009, where she dedicated a significant part of her practice to pro bono legal services. She's also worked with national and local nonprofits, and with founding director, Professor Bill Hing, she started the Immigration and Deportation Defense Clinic in 2015, which means it is the 10th anniversary of the clinic this year. And through that clinic, as many of you know, the students, staff, and faculty are providing representation to immigrants in immigration court. I also see that we have an immigration judge and alum in the room today. Hello, welcome. The clinic also assists children who are eligible for SIJS, Special Immigrant Juvenile Status, in family and probate courts all over the state. And Professor Brown also teaches U.S. asylum law and family law. So thank you, Professor Brown, and welcome up. So next, I have the honor of welcoming Professor Jackie Kelly-Widmer, who founded and directs Cornell Law School's 1L Clinic. So first-year law students, she's also written a great piece, Why Not a 1L Clinic? And it's the Immigration Law and Advocacy Clinic. She teaches first-year lawyering, advanced immigration clinic, and seminars related to migration and the law. She's recently been involved with Path to Papers, which is a really large pro bono project that helps DACA recipients pursue work visas and other pathways to legal permanent residency. And we'll hear a little bit about that today, as we need to kind of get creative for that population and others. She has, she writes in the arena of DACA, but also thinking about parole from detention. She's, running an active clinic. She writes on naturalization, SIJS again, other humanitarian relief. She served, prior to going into academia, as an Equal Justice Works Fellow. I was also an EJW, so at La Raza Centro Legal in San Francisco. So she has Bay Area roots, although she's joining us today from the East Coast. And she focused then on representing immigrant youth and families in applications for immigration relief. She also has taught legal writing at Berkeley and also clerked at the San Francisco Immigration Court. So we have some common ground here, again, through the DOJ Honors Program. So thank you for being here with us and traveling all this way today. Okay, so last but not least, our third esteemed panelist today is Sabrina Rivera, who is an assistant clinical professor of law and director of the Immigration and Deportation Defense Clinic. So we see a theme here, all these clinic directors, and she is at the Western State College of Law in Southern California. And she, again, supervises students working on immigration cases before the courts and federal immigration agencies. Her research, and some of what she'll talk about today, thinks about immigration law and thinks about the ethics of layperson legal aid initiatives and access to justice. So thinking beyond attorneys, we know that representation rates are dismally low, and they've actually fallen since 2017. We're at like 30% representation in immigration court, which means there's about 70% of people who don't have attorneys standing up for them in court. So how can we expand that? How can non-lawyers assist? And so Professor Rivera has been thinking about that issue quite a bit. She served as the inaugural director of the Orange County Justice Fund, which is a nonprofit working with folks who are defending themselves against deportation. And she was a supervising attorney at CABESIN, the Central American Resource Center. And she helped to establish immigration and legal services at 8 CSU, California State University campuses throughout Southern California. She has also taught at UCI, UC Irvine Law, and speaks regularly at local trainings, national trainings. She's co-authored a report, The State of Immigration Enforcement and Legal Resources in Orange County, which was published just in May 2023. Thank you for joining us, Professor Rivera, and welcome up. About an hour and 5 minutes for this panel. So just to give you a sense, we're going to actually start with a moderated discussion and hear from all three panelists on various issues. We're also going to try to establish a solid foundation for the day and bring everybody up to speed on what's been happening, right, in this first 11 days of the new administration. And then we're going to have some time and open it up to audience Q&A. I think one thing to keep in mind here is that we are going to be talking about these issues sometimes probably throughout the day in a rather dry and sometimes technical way, right? It can be a little bit esoteric and, and sometimes in a non-emotional way to some extent. And I don't want that to undermine our collective understanding of the very real harms and human harms, the fear and actual results resultant harms that we're seeing resulting from some of the policies we're going to be talking about today. So I just wanted to acknowledge that up front. I'm going to sit down really soon. So we want to start with an understanding of what the current situation is in this extreme anti-immigrant environment. Professor Hing has alluded to a lot of this. And it's not new, right? This is new old reality, but it is very fast, furious, highly organized, and empowered in a different way today than it was 8 years ago. And we've also seen, the administration shaping the narrative over and over again. I'm thinking about just so many kind of theatrics that we've seen. The new Department of Homeland Security Secretary standing in a bulletproof ice vest, right, in New York, conducting raids to evoke the sense that we are in the midst of some kind of immigrant invasion and we are under attack. And not necessarily recognizing the facts, the reality, the numbers about where we are actually today in terms of immigration. So I'm going to turn to our panelists. I'm going to start with Professor Brown to talk a little bit about what we've seen, right? What is coming down. Even on that first day, we had 8 executive orders directly pertaining to immigration, and talk a little bit about what they say, what we can take away from them, and kind of what we can expect coming down the pipeline. And now I'm going to sit down.
Yeah, sit down. I also need help on, there's a lot to keep track of with the executive orders, and I definitely don't pretend to know what's in all of them. There's definitely some themes that everyone can imagine, and some that everybody I'm sure has heard of, some of the most shocking ones and destructive, I would say. Birthright citizenship, that was one of the big ones, although luckily we have an injunction, and so a lot of what we're talking about is like the fight on the other side. These are all executive orders, right? They're not like the law has changed, but they definitely give a roadmap for what, at least what the plan of the administration is, not necessarily what's going to happen. So this would prohibit state authorities from issuing birth certificates to children that were born to undocumented parents, basically, right? So it's a big change and up against the Constitution, the 14th Amendment. We have the expansion of expedited removal in the interior of the country for people that have not been here for 2 years yet. And so that would allow the government to essentially deport people without, I would say, due process, if you can't prove that you've actually been in the country for 2 years. We have closing of the border under the invasion, we're being invaded, and so currently there's really no way into the United States to seek asylum. That is something that actually has changed right now. So prior to this, people would go to the port of entry. They also can seek asylum in other ways, but this would be a main way, and this is also something that's been restricted over the years. This isn't just new right now with Trump. It's been going on since the first Trump, but there's no way to seek asylum at a port of entry right now. The past couple of years under the Biden administration, CBP-1, it was an app that was used to make an appointment if you were not in the United States yet, to make an appointment to go to a port of entry so that you could apply for asylum, and they stopped CBP-1. Basically that happened like within minutes of the inauguration. And then they also reinstituted the Migrant Protection Protocol. It's called MPP, which basically means that people that are trying to enter the United States in Mexico would have to wait in Mexico, and there's a whole series of problems and dangers involved in that. So those are kind of the two main things that have happened to people that have not been able to enter the United States. So we're counting on applying for seeking asylum because they've been fearing that they will be persecuted in their home countries. Then there's sending the military to the border, so they increased 1,500 military personnel who apparently were the ones that they sent were waiting in Los Angeles to fight the fires, but they decided to send them to the border instead, constructing barriers. And before that, there were already, I think, 2,500 military personnel that were there. So increasing the military, this goes in line with the whole narrative of we are being invaded and we have enemies. I would say in the early 2000s with President Bush, everything was against terrorists, but now we're seeing that we're supposed to think that the new terrorists or the new enemies are immigrants and asylum seekers, especially. I think the change in the narrative over the past 10 years in terms of the demonization of asylum seekers is pretty striking, and one of the most disturbing aspects of how much society is kind of bought into that whole ideal. Other executive orders here? I know, go ahead.
Yeah, I think we also want to hear a little bit about some of the real ways that organizations that are representing and assisting and providing legal orientation programs and others to immigrants have been affected by what's happening. Like, how has that happened? Do you want to guide us through that, Professor Rivera?
Yeah, I mean, there's so much happening, right? There's like over 80 policy changes that we're tracking, and that includes a mix of executive orders and memorandums, different types of communications that it's trickling down right from the executive orders. So there's a lot you guys are probably not seeing what we're seeing behind the scenes. So I think those are a few of the ones that I think are causing a lot more buzz right in the media. It's pretty outrageous. But one in particular I wanted to highlight was the executive order called Protecting American People Against Invasion. Have y'all read that one? I mean, take a look at these executive orders. They're pretty great too. It's a great read. But what I wanted to point out about that particular executive order is that it seeks to force a reassessment of how the federal government funds NGOs, essentially, that deliver legal services, right? And so it's not just about urging them to review, right? Like, are you spending the money the right way, the way we want you to? But then they're also threatening taking back funding. Have y'all seen that provision? It's called the clawback provision. And so in their investigations, if they find that certain or NGOs have misused the funds or used it in a way that doesn't, see fit to their mission, they can essentially ask them to return the money to the federal government, which is pretty scary, right? Because a lot of the sort of legal service organizations have probably already spent that money. And so I think essentially they want to put them out of business, right? So they don't do this work. So it's not just scaring the migrants and immigrants on the ground, but it's also about a chilling factor, right, against us, the legal community, about like, hey, are you sure you want to do this work, right? And if you're funded by the federal government, it's not about are you sure, like you shouldn't do this work, right? So I wanted to point that out. And then you probably have heard too that there's already implications, right? Impact, right? So for example, in Southern California, I was just telling one of the students here that one of the organizations in Southern California, Esperanza Immigrant Rights Clinic or Project, they get funding from the federal government to run the help desk centers, the LOP programs, right, legal orientation programs. And they were in the middle of their workday. So were my students, by the way, because they work with Esperanza, and they were ready to go to work on Monday, and literally were told to stop working halfway through their work. And so I met with the director, and she was like, I don't know exactly what to do. Like I have clients, I have people. So it's been messy, it's been a mess. And I think the reality is that we're still trying to figure out, right, the impact and the harm these EOs and policies are gonna have, because we're just starting to see the impact a little bit trickle down in practice. But that's just one example.
Did you want to add anything?
No, it's been really helpful to hear this summary, even though I've heard of these, been reading them, but to have it all collected in one place is really helpful. And I would just add that there is another directive in the enforcement space saying that formerly safe spaces of schools and hospitals and churches are no longer protected from ICE activity. Professor Haig alluded to that too. And so we're seeing a lot of fear, for example, school districts reaching out to us to say, what should we do if ICE comes? We never had to do a Know Your Rights for a school before. So we're seeing that real shift and fear for people, for example, to send their kids to school. And we also are seeing targeting of sanctuary cities, right? The administration wants to stop localities and municipalities from having sanctuary ordinances. And a sanctuary ordinance or a policy really usually just means that there is a policy of local law enforcement not cooperating with ICE. That's generally what it means. And as you heard in my bio, I'm teaching at Cornell Law School right now, and just yesterday afternoon in Ithaca, there was an arrest of an undocumented person who had been released from local law enforcement custody by the sheriff in Ithaca. And ICE agents encountered him outside of the social services agency downtown and arrested him. So my phone's been blowing up about what's going on in Ithaca, and there's an article in the New York Times just this morning saying that the DOJ is considering prosecuting the Ithaca sheriff for not executing the ICE detainer and holding that person until ICE could get there. So we're really seeing targeting. Ithaca's a small city, but it's one that has declared itself and re-declared itself a sanctuary just in the last week. And so I think we're going to be seeing more of these actions too.
Okay, so that's a lot. There is more, right? The administration, there's also an executive order stopping all the parole programs that were created under the Biden administration to try and have a little bit more. Those programs are controversial, but there are certainly people who have been brought in under those parole programs from Cuba, Haiti, Nicaragua, Venezuela, and then you also have the Afghan population too, many of whom are still paroled, which is kind of a temporary legal limbo, not really status. And so those folks are also thrown into limbo, and it's unclear if the administration is going to pursue action against them, right, as they seek different pathways to gain legal status. I don't think we've talked about the suspension of the refugee admissions program, but the president has the power to set, an annual determination on refugee admissions, and it crept up under Obama, it went way down under Trump 1. Senior White House advisor Stephen Miller said he would be happy if no refugee foot ever touched U.S. soil again, and he's now, back behind the driver's seat on these issues. So they have suspended it for 90 days. It will be revisited every 90 days. But it means folks who were vetted, had all their background checks done, were set to be resettled, including Afghan allies who assisted the U.S. During the war in Afghanistan, are not allowed to get on planes, right? They're just, again, in limbo, and no refugee admissions are being permitted. There's also been this Foreign Terrorist Organizations, EO, which basically further entrenches national security frameworks into immigration policies. It basically designates organizations, including Mara Salvatrucha, MS-13, which is an organization Trump likes to talk about a lot, transnational criminal organizations, and designates them as foreign terrorist organizations, which sounds maybe, okay, reasonable, except for the way it will be enforced is to kind of sweep up anyone who's ever come into contact with those organizations, including people who were simply victims of their violence. We're also seeing foreign terrorists and national security threats, an executive order focused on that, which basically asks the agencies to identify countries for potential possible travel bans. So just like we saw under the first administration, Muslim bans, African bans, increased vetting and screening, also potential targeting of non-citizens, including students who protested what's been happening in Israel and Gaza, and folks who've been speaking out in favor of Palestinian rights. So there's a lot to digest. There's some I know some folks in the room work in the criminal space. There's one that asks federal prosecutors to seek the death penalty against undocumented immigrants for any crimes where the death penalty might be a potential punishment. So just a lot happening. These are, of course, executive orders, these kind of proclamations from on high, and at this point in time, they direct the agencies to take certain actions. It is not clear how they will be actually implemented or when, and so something that is kind of like calming me a bit is this is all issued at once, it doesn't all happen at once, and so we do still have time to respond, to react, to plan, to imagine what we can do. And we are going to see, of course, the role of courts and lawyers who already have filed suits challenging, some of the things Professor Brown described, like the expansion of expedited removal throughout the country. There was a suit waiting to be filed because we knew it was coming down. So, given all of that, which is a lot, we should maybe just take a collective breath, okay. Legal representation, right, and engagement from our communities is going to be critically important in defending and protecting and standing alongside immigrant communities. So we're going to talk a bit about how we should be doing this and how we can maybe think about ways to expand access to accompaniment and assistance in this era of really just ever-expanding need. So I'll start, well actually maybe I will start with Professor Rivera
to speak about, before we get to the attorneys, and we have so many budding immigration attorneys, thank goodness, in the room, can you talk a little bit about some of the pathways you see and some of the thinking you've been doing around how we get non-attorneys to engage laypersons, right, as you call them, with folks who are directly impacted?
Yeah. I know this is a friendly space, but I want to preface by saying also that before I get into the conversation of non-attorneys engaging in legal work, because I know not everybody understands that, but I also want to point out that one of Trump's officials, Homan, just recently, said that the Trump administration is going to be unapologetic, right? Which is a term that stood out to me because, we use sometimes that word too in our work, right? And it moves us, right, to do the work that we do. And it just kind of shook me a little bit because I'm like, okay, so they are really full force believing in their plan, right? And so if that's so, then we need to also rethink, right, the way we do things as lawyers and advocates. So I think in particular, for me, I've been really, in the last couple of years, been thinking around the role of laypersons and how they engage in legal work, but also attorneys and what their role is in collaborations with laypersons who want to engage in legal work. Many people don't know, but the first people to practice immigration law, anyone know? Future lawyers don't know who the first lawyers were, right? Women social workers, right? Yeah. And then we forget about that, right? Then the private sector came in and took over, right? And made it their own. But I think it's important to remember our roots, so we know, right, like how we got here, where we are today. I think collaborations with laypersons, people who are directly impacted, lawyers, especially collaborations with local jurisdictions are going to be very, very essential in the next few years. Even though the Trump administration is moving to basically destroy everything that we've worked up to, get it to where we are today, and it wasn't great where it was, but the legal provisions that allow attorneys to represent people or even laypersons to represent people still exist today, right? And there's even in their memos and their EOs, like they cite to legal provisions, right? They can't just change them overnight. And so a lot of people don't know that the legal provisions, the law allows actually for laypersons to represent people in court. I actually just met one this morning, and he's an accredited rep, right? And he represents people in their immigration cases. And he's thinking about coming to law school here to become a lawyer. And I was like, oh, you should just stay as an accredited rep, it's cheaper. Don't say it, I don't mean that, right? But that's important to know, right? If you wanted to engage in immigration legal work, you don't have to go to law school, right? You should, because I'm a lawyer, you should come here and be a lawyer. But if you want to be a lawyer, I think an alternative is how do I lawyer differently, right? How do I partner with laypersons, teach them how to engage in legal work? And the reality is we can. The ethical rules allow us to. Depending, I guess, on the state, but also the federal legal provisions allow us. And one of the roles that I focus on in my paper that I'm writing is reputable individuals. Have any of you ever heard of that role before? Not many of you. It makes sense. In my research, I found that less than 100 people took advantage of this legal provision that allows laypersons to go to court and actually represent somebody in court.
Oh, let's move the mic so we can get a little closer.
I'm so sorry. Usually I'm pretty loud.
It's hard for this room. It's hard for us in the center of the room.
Got it. There you go. Thank you. There you are. And in my data, I found that less than 100 people actually utilize this part of the law, which means to me, can mean different things, but to me it means that it's underutilized, right? And so I urge, attorneys, future lawyers to kind of rethink and shift the way they lawyer and how they deliver pro bono legal aid to laypersons who want to engage in legal work and the legal space, right? And because the legal provisions allow them to do that. And I think now more than ever, we need people to be in immigration court, be in these spaces where violations of due process are happening left and right. We don't know what's happening in those courtrooms. We don't know what's happening in Texas, in these dark places where there's no lawyers, no law students, right? And so I think if there are people in the community, laypersons, loved ones of impacted people who want to get involved, lawyers have an opportunity to work closer with them, and the legal provisions are still on your side as of today.
Yeah, that's so important to kind of highlight that collaboration aspect, right? And that it can go beyond collaborating with other attorneys. I did a study under the first Trump administration in 2020, a survey of asylum attorneys on secondary trauma and burnout. And the attorneys who reported the highest rates of secondary trauma and burnout were solo practitioners, right? People working on their own who didn't have that kind of natural environment to debrief, to process. And so that's one idea for the solos and people working, more in isolation to partner beyond the legal profession. So coming to the legal profession, Professor Brown has written a piece that will be forthcoming in the Law Review, and it discusses how you think attorneys should be approaching this work. I'm hoping you can kind of share some of your thoughts and some of your kind of top line points of that piece.
Sure, thanks. Yeah, so we're moving on to a person, a client, an asylum seeker who actually was able to, is in the minority still of people who are able to have legal representation, because it still is a minority, especially when you get outside of places like California and New York. And what responsibility you have as an attorney who's representing an asylum seeker. You're not just like off the hook because you're doing the work, that you're an immigration attorney or you practice asylum law. That's not enough. It's how you practice that really matters. And I think that, a trauma-informed practice, it's beneficial obviously to the client, which I can talk about a little bit more, but it also, I believe, benefits you as an attorney representing your client, because it is something that can weigh on you, especially after you've been doing it for a while. 20 years in, it's a lot. You start to really have the stories of your clients that live with you. So my piece is really about how to continue to be inspired by your clients and motivated, and not let all this external dialogue, all these demonizing narratives get to you and make you feel like you don't have a chance in the world anymore. And I think that during the first administration, there was a lot of stuff that kind of came down regarding asylum law that made a lot of attorneys feel like, oh, I'm never going to win in court anymore, I can't make this argument anymore, there's no such thing as protecting women from gender-based persecution, because the Attorney General, decided to certify a decision to himself and define who would be considered somebody that's eligible for asylum, and really tried to change up a lot of the case law that actually was, there's federal circuit precedent that was higher than what he was issuing. But there's this defeatism that happens when there's so much going on, all the executive orders. It's really hard to just stay focused on what's in front of you, and that's your client. And so that's pretty much what I'm arguing. It's pretty simple, but when you're in the work, when you're constantly being distracted really by what's going on every day, sometimes you lose sight of your actual client who's in front of you. And the piece that I wrote about, I was really motivated by clients who came to me for cases on appeal, and for cases involving needing to reopen their immigration proceedings because they were represented by an attorney that really didn't do the work. The client was actually, I've had so many times where a client was shocked to be talking to me because I was the attorney. That, oh, you're the attorney, because they never had the experience of actually talking through their case with an attorney, and so I do talk about fact-finding being such an important part of an immigration lawyer's job, especially in asylum cases. The definition of a refugee is what we have to prove in order to win a case. And so a refugee is somebody that has suffered persecution or fears they will suffer persecution on account of one of 5 protected grounds. And it's pretty strict in terms of the nexus that you have to show why somebody could be persecuted. And one of the most common grounds that, currently at least, and for the past 10 years, I would say for at least our clients and a lot of other, I would say, organizations in the Bay that do this work are people that have fled violence, gender-based violence, family-based violence, or gang cartel-related violence, and so they have to show that they're a member of a particular social group, and it's this legal term that you have to prove exists, and it's very, very fact dependent. And so it's always shocking to me when I read through a declaration that had been submitted or the country conditions evidence that was submitted to prove this, and there's really no evidence, and there's no facts, and it's clear that that attorney didn't actually talk to their client about their story and get a full and understand the legal argument. And so, that a client is depending on their attorney to make a legal argument that is fact specific. And so it's just important. It sounds really basic, but a lot of people don't have that chance to work with their one-on-one with their client over a period of time. And then the trauma aspect of it, if somebody is never working with their attorney and then all of a sudden shows up in court for their hearing, and that's the first time they're meeting their attorney, which you'll be really saddened to know how often that happens, that is a traumatizing experience in itself. And when we're representing asylum seekers, trauma is an integral part of their actual claim. Like, we can't avoid their trauma. We actually have to use their trauma to make the argument. And so we have to take care of their trauma. And we can't be another person in this long line of people that have already traumatized and dehumanize them. As an attorney, we actually have to be like the end of that, And so it's just something that we have to keep reminding ourselves, even as we gain more and more experience, and we have experience with these kinds of cases. We have to look at each individual person as their own case, their own. This is somebody separate from you. Might have experience doing this kind of work. You might have had this kind of case, but this person is their own person, and we have to work one-on-one with our clients and in a lot of ways the trauma.
Yeah, so first of all, I'll just say how lucky Professor Brown's clients are right in her clinic to get that kind of approach. And I think that what she's describing, right, attorneys sitting down and directly hearing those stories of trauma, that's certainly how I always lawyered, right, as an asylum attorney. But I think it is protective in a way, right? So it is exposing you to a lot of trauma, what we call trauma exposure, but it also can be protective because you are directly sitting with them. You have this sense that you've heard the story, you've explored every possible avenue, gone down every rabbit hole, and you've done your best to fit their narrative into the confines of the law, right? Which does re-victimize and essentialize people in many ways. From the study I referenced that I did, a lot of attorneys, I had about 300-something attorneys give me just their thoughts. I just did an open-ended question at the end. And many of them shared, look, it's not the client stories that's burning me out and subjecting me to the secondary traumatic stress. It's not hearing the stories, it's the system, right? It's feeling complicit within this broken, dysfunctional, unfair system. And that was during 2020, that was during Trump 1. Actually, half of the people surveyed were during the pandemic, so it was a time, but we are coming into a time again right now, we're in it. And so it's going to be so important to openly discuss these issues, right, at a law review symposium, at a law school. The word trauma coming up is like very heartening to me.
Yeah, just one more thing, and you've written about small wins. And when you're doing the kind of work that I just described, and you actually are fighting and you're with your client every step of the way, if in the end they lose their case, which obviously is still goal number one, but if you lose, that client knows that you were with them all the way and you've done everything. It doesn't have the same feeling as if you feel like, God, I wish I spent more time on this, or I wish I knew that part about their lives, or I wish, you do have a small win by being that person that still was advocating, because so many people have never had anybody advocate for them in their whole entire life, and you could be the person that's still advocating for them, and that is going to make you feel better and less traumatized at the end to know that you actually, you fought the fight,
Right. Yeah, we're going to have to do, some talking about sitting with losses, right? Because that's something that's going to come and does come in every attorney's career. But directly hearing those stories can really help, and it might take 5 meetings, 8 meetings. My personal record is 27 to draft a client's declaration. That is extreme, but it happened. And then at the end of that process, when you can sit down and go over everything that you took in and framed and got in chronological order in a credible way that an adjudicator is going to understand and be able to internalize. Sometimes the clients will kind of like break down and cry happy tears because they're like, you listened, right? You got this down on paper. And that bearing witness is going to be increasingly important, right? Standing with people alongside their journeys. So I want to shift gears a little bit and talk about a totally different population. I want to talk about our dreamers, DACA. And Professor, I'm not used to calling you Professor because we know each other, but Professor Kelly Widmer, can you talk about DACA? Just give us very baseline, what is it, where does it stand right now? And then some of the work you've been doing, exploring, pushing creatively different opportunities and pathways to status for this population.
Yeah, thank you so much. So DACA is a program that you've heard about for many years, and it's an acronym. So it stands for Deferred Action for Childhood Arrivals. This was a program created by the Obama administration in 2012, and the idea was to protect people, young people who had been brought to the US when they were children. And you had to meet certain criteria, like being undocumented on the day that DACA was announced, and having little to no criminal history, and having some educational background. And you had to be 15 to apply, but under 30 on the day that DACA was announced. So that was announced in June of 2012. And I was actually in law school at the time, but since being in law school, I've been working with DACA recipients the whole time. And DACA is in the news frequently because it has become a program that's subject to a lot of litigation. In the first few years of DACA, there actually was no litigation about it. It just opened up, and what did it do? It allowed this community of young people to basically register if they met the criteria, and then they would have protection against deportation for 2 years. That's deferred action, right? The deferred action part of the name. And they also would receive work authorization for 2 years. There's no pathway directly from DACA to anything else. A common misconception that I sometimes am explaining to clients even who have DACA is that there's not a next step that directly comes out of DACA. It was meant to be like a stopgap so that this group of young people would have work authorization and protection, and then eventually Congress was supposed to pass a bill that would allow them to have this more long-term status. But Congress hasn't done that. And the Obama administration tried to expand DACA and also offer deferred action for parents of children who had citizenship or lawful permanent residence. But the Supreme Court struck down that expansion in 2016. And so that's when Texas and a coalition of other states were like, hey, wait a minute, DACA is happening and we don't want that, right? And so we have seen, and I won't go into all the details of litigation because we could be here a long time, but essentially DACA has gone through litigation in various jurisdictions. The Supreme Court has not yet weighed in as to whether DACA itself was a lawful act of executive power, but has said that the expanded DACA and DAPA were not okay, and has said that the rescission of DACA, which President Trump did in his first round, was unlawful. That is, the rescission did not follow the correct procedures, and there was a high reliance interest on DACA. So we've had DACA kind of sometimes open, sometimes not, for quite a while, but really it hasn't been open to new registrants since 2017, when Trump rescinded DACA, except for a little tiny window in like 2021. But that closed quickly. So what we're seeing now is that DACA, the legality of DACA is still being litigated, and the Fifth Circuit heard a case in October around the legality of DACA, and just days before the inauguration released the decision which said, well, we do think DACA is unlawful, but actually we're not totally sure if you can do the work authorization part of DACA. Because remember, it's deferred action, but it's also work authorization. And there's maybe a possibility that the work authorization part's really the unlawful part, but maybe the deferred action could be okay. We want to maybe think about these two things differently, and so they remanded the case back to the district court. We were all ready for it to go forward towards the Supreme Court, but it hasn't happened yet, and we don't know how long it will be. In the meantime, we're really trying to think about how we could work with this community that does have DACA. Right now, there's about 530,000 people who have DACA. There used to be 800,000, but over time, as you know, it hasn't been open for anyone new. And some people have lost their DACA for not renewing it, or maybe transitioned to better status. And so the project that Professor Harris mentioned that I'm running is called Path to Papers, and that project is trying to identify other long-term options for DACA recipients that that actually are viable pathways within the law. And so the paper that I submitted for this symposium talks about how DACA is an exercise of executive discretion, deciding that this group does not need to be at risk of deportation. And you can sort of push the boundaries of that discretion for this group in particular to try and find alternative pathways towards employment-based visas, in addition to humanitarian and family-based visas. And so our project is really trying to work on educating both DACA recipients and their employers, and even most other immigration attorneys, how can someone actually move from DACA to an employment-based remedy? Should I go on?
That's the
That's the thing.
no, that's the how.
How, okay. Okay. Great, okay, I'll keep going.
Don't leave us hanging.
Okay, so I'm just, it's very technical, right? And
Yeah.
you said at the beginning, like, this is going to be
Tell
some
us how.
sort
Tell
of
us
like dry conversation about how we might do this. But the answer is that there's a waiver in the Immigration and Nationality Act called the D3 waiver. It's named after its provision in the Immigration and Nationality Act, but it's basically a waiver that's existed for decades that allows the government to waive any ground of inadmissibility on balance if they decide that would be in the public interest. And so you could imagine someone who's trying to apply for a visa of any kind, or it could even be family-based visa, and it turns out that they have a criminal conviction, say. Well, this waiver could waive that. Now, we are in a time when that probably won't happen, but we have seen D3 waivers used for a variety of different reasons of inadmissibility. But for DACA recipients, their most common ground of inadmissibility, the thing that's standing in their way from receiving a work visa, is unlawful presence. That is, of course, time in the US without any kind of lawful status or deferred action. So DACA itself does provide that cover for someone to be in lawful, sort of, in lawful DACA. It's not a status, but it is a form of relief that stops people from accruing unlawful presence. So since last January, our team has met with about 600 DACA recipients, primarily folks in the Bay Area, and found that about 30% don't have any unlawful presence, actually, because they received DACA before they were 18 or 18 and a half. Young people don't accrue unlawful presence. Once you turn 18, you accrue unlawful presence, and it means that if you have over up to 6 months of unlawful presence, it's a 3-year bar to returning to the US if you leave. And if you have over a year, it's a 10-year bar. So what we need to do is find the way to forgive that unlawful presence so that people can go to their consulate outside the US, pick up their H-1B visa or other work visa, and come on back. But they're barred from doing that because once you leave, you trigger that 3 or 10-year bar because of the unlawful presence. So we've been working on this D3 waiver, and we worked a lot with the Biden administration when that was possible to try and streamline this process of receiving the D3 waiver, especially for people who fit in DACA-like categories, have lived in the US, been educated in the US, and are trying to return to the US with a work visa for a US employer.
Thank you. We told you it would get kind of dry and technical.
Totally.
And, the famous quote from, I think it was a Second Circuit judge, is that immigration law is, more of a labyrinth than the tax code. So,
Right,
tax
right.
and immigration, tons of fun.
But I do think there's a little, if I could add, just a little connection to what we've been talking about around what Professor Brown was just saying about people like actually feeling listened to, and sometimes what you're doing is walking that journey alongside folks. We are talking to a lot of DACA recipients who just have never had someone like fully work through what all their potential options could be. So many people just got DACA and then they just go back to their same legal aid office and they just renew their DACA every 2 years. It's tiresome, but they're doing it. And they have not figured out or had another consult about what their options might be. But in the meantime, they've gotten their degrees and they've gotten a professional job that could really set them up for a work visa. And so we are finding even the folks that don't have options are so grateful to have just been listened to for the time that we're in a consult with them and really truly understand their options so that they can be empowered to make whatever decisions they need to make.
Yeah. And just a flag for folks, hopefully you can stick around because this afternoon we'll be hearing from one of the most famous, maybe the most famous dreamers,
Yep.
Gaby Pacheco, who is just amazing. She led a march in 2010 from Miami to DC, the Trail of Dreams, and was very involved with DACA coming into being, and I'm sure she may be speaking a little bit about that. So stick around for the keynote at the end of the day before our reception. I want to talk, to kind of shift gears a bit, and you referenced, right, discretion, and you also talked about the restrictions on DACA, like who counts.
Yep.
And this kind of concept we have of the good immigrant versus the bad immigrant, right? And we only want the good ones, and there's this kind of cookie cutter image of what we want. And with Professor Brown, we talked a little bit about how we're kind of trying to fit people within the bounds of the law. I just want to ask you just to stay with you for a couple more minutes, Professor Kelly Widmer. You've done some thinking about how much of immigration law is quite essentializing, right? You have a piece essentializing cultures in U.S. asylum law. Like, what do you mean by that? And then we'll talk a little bit more about narratives and how we can frame them.
Yeah, absolutely. Thank you for that question. And I practice in asylum as well. And so I wrote with my co-author, another law school professor, Estelle McKee, an article about how the system forces advocates and clients to kind of play into stereotypes about their culture, where they are from. Because we see that one of the elements of asylum is that the government is unable or unwilling to control the persecutor. And so that requires advocates to say, basically throw the home country government under the bus and say they are not doing enough. They can't protect this person, or even they don't want to, right? It's unable or unwilling. And in fact, people have really complicated relationships with their home countries, and they often are very sad that they had to leave their home country. It wasn't really like a choice, it was more like fleeing. And yet we have to, as advocates, kind of be complicit in perpetuating the narrative that the government of that country cannot protect a person. And we see this a lot in Central American cases, like with women who have suffered domestic violence, and we see courts actually using the word machismo to describe the cultural situation in some Central American countries or Mexico, and then other circuit courts picking up that word and continuing to use it. And then as an advocate, you have to think about, well, how am I going to handle that, right? Because I'm trying to build a relationship with my client, have her trust me, have myself listen to her story and not flatten her to just like a victim from a place that's terrible, right? But actually as advocates, if you don't play into the narrative or you complicate it more, then it makes it harder to win your case. And you don't want to distract the judge with possibilities that actually it's not so bad. And so it is, I think, something that advocates really wrestle with, and even just naming it is helpful. But I also sometimes name it when I'm talking with my clients too, right? We're going to highlight this part of your story or this part of what happens in your country, but you and I both know that's not the whole story.
Mm-hmm. Right, moving away from these kind of one-dimensional boxes, flat boxes, right?
Which DACA recipients are stuck into as well, with being the good immigrant, right? You're the young kid, you are blameless, you went to school, like very poster child good immigrant, but that is not fully inclusive of the rest of, for example, Dreamers communities, like their parents.
Right. Yeah, and we saw that with the attempted expansion to DACA, right? Parents of child arrivals, and how that was really quashed.
Yeah.
So narratives are so powerful, right? And we are seeing so many examples of attempts by the Trump administration, pretty successful attempts to vilify groups, as Professor Brown said. I grew up in England, and in England we have always, in my whole life, right, we've always vilified asylum seekers as bogus economic migrants. It's like very much a common theme or narrative. It was not the same here. People didn't even know who asylum seekers were. They thought you were talking about, an asylum for folks who are having mental health challenges, right? When you would say you did asylum work. People really didn't know. So that is something that has changed, with Trump and with the Trump movement and MAGA, is this vilification of asylum seekers as dangerous, as coming to take over And the words chosen, right, from the first campaign, you know, they're sending us their rapists, their criminals from these shithole, sorry, I'm not allowed to say that, countries. And even just the use of the words illegal alien, right? It's in the statute, but those words are so dehumanizing, and we've seen the press, even the Supreme Court, move away from using those words. So I want to ask you all on the panel, in this moment, right, how do we shape the narrative, or how do we refuse to participate in the perpetuation of harmful narratives? I think, you know, one thing you referenced, Professor Brown, was not falling prey to defeatism. And I'm just wondering if you can say a little bit more about that as it relates to how we frame and how we talk about these issues.
I just want to quickly, I totally agree with everything you just said. And one of the ways that we try to get around that, especially teaching country conditions evidence and how to use it to students and how we practice, is to focus on the problem versus like the actual society in a lot of ways.
Yeah.
And so a lot of times I like to highlight everything good that happened in somebody's life before this problem happened that forced them to flee. And so, I mean, we have so many clients that were living happily on a beautiful beach in El Salvador, you know, selling food at their business that they came up with, and then the gang did come through and everything changed, but it had nothing to do with El Salvador at that time being so horrible or being, you know, and yes, there's these moments in time where the government can't or doesn't want to, right? But we can frame it as like it's a time period versus a culture. And then, you know, with the narratives, that's where, you know, as an attorney, you have this responsibility to make sure that you aren't, I think, contributing to the narrative. But everyone else in the room, everyone that feels passionately about what's happening, has that opportunity, not even responsibility, but a huge opportunity to push against this narrative. You know, they're winning in that way. The whole reason all of this stuff can happen is because somehow they convinced so many more people in the past, say, 12 years, because I do think it started happening with Obama when he started family detention, you know, with a few of the facilities that started in 2014. That's deterrence policy, which deterrence policy has been around for a long time, but deterrence against asylum seekers, that's been going on. And they're winning. They're like, people are really, like, people I know, I could say that might have been more sympathetic towards what I might describe as the work, to now it's like they don't feel the same way, you know? And so I think that everyone here has the opportunity to share, and not just share oh, this person, we have to feel so bad for them, we have to save this person that's fleeing persecution, but celebrating the people that we're helping, like celebrating that person and why they're here. I mean, I feel so lucky that I actually know like hundreds and hundreds and hundreds of asylum seekers. They made my life better. Like they've added to my life. And I think that so much of it is showing how much anybody that's had any kind of contact with anybody that wasn't born here, like we can say that it's a contribution. It's not something that we have to fix. It's not an invasion that we have to fight. It's something that we actually have to say we want this to be here, these people to be here.
I love that. Sorry, I'm tearing up. But going to Professor Rivera, do you want to add in any thoughts on this around kind of narrative, storytelling? How do we do this?
Yeah, I mean, I'm thinking about DACA, and I felt like that was really, I mean, I haven't been around that long. I'm 86, so I haven't been around that long. So I think of DACA, and I think that was the first time in my career or life that where I was like, oh, this narrative is a little dangerous, right? And it was a collective decision, to the campaign for DACA and everything. It was very strategic, and it worked. And it worked, but now we are where we are. And I think that was really where the first time where I saw the power of narrative, where it could work to your advantage, right? And then eventually, when I started teaching students, right, I had to have like a framework, right? Most of you are students, right? I think in the room. And that's when I teach students about the power of critical storytelling. And it's kind of like what others are saying, right? Which is like, we know what the government story is. Right? We know their story. We know the paperwork. We know that they're charging them as whatever, murder, whatever, right? We know their story. So our job as advocates and attorneys is to find out their story, right? And it's not always perfect. It's not perfect. Why? Because we're not perfect. No one in here is perfect. Everyone has, dark spaces in them, they have this bright space, you know, everyone has a story. And so our job as attorneys is to find that story, investigate, get to the what is it? And then we figure out how we present it, right, to the courts, in writing, whatever. And that's a process that you go through with your client because they ultimately decide what their story is that we share and how we share it, right? So it's not up to us lawyers, at least that's what the client-centered lawyering approach shows. So it's not up to us, it's them, right? And it may not always be favorable facts. I think we have to sometimes give into those unfavorable facts. We have to put them to the forefront because it is their story. And I found in my practice that those cases are successful too, if you illustrate them correctly. And so I urge you, future lawyers, to think about a framework, right, of how you investigate your client's story, and then how do you translate that in a way where it doesn't harm your client, but it also doesn't harm every other person, right, in that community. Because when we advocate for DACA and that they're, it's no fault of, it's no, to their own fault of their own, they're here. It's like, well, a lot of people are here without no fault of their own, right? And so we're letting other narratives take over when we, have certain dominant narratives, right, take over. And so I think it's important to remember every person has a different story, even folks that have DACA, right? And the folks especially that were left out of DACA, right? And I also want to talk about very briefly about the politics of respectability, right? Angelica Chazaro talks about that in her piece, and it stuck with me for many years. But it's basically, right, when we as advocates are respectable, right, to what the narrative is, we try to play nice, right? We try to, we know what's happening in the courtroom, we're trying to make everybody happy. And I think sometimes it's okay to go against that, right? And so if you're in the courtroom or if you're on the streets, wherever you decide to advocate, right, we don't have to be respectable in the way that they want us to, especially under this time, right? And deciding different narratives that fit the people that we're actually serving.
That's really powerful, I think, and part of kind of resistance and how we all get through this together. So this is the last question for me before we'll open it up to questions from you all out there. And the question is, all of you are really, truly in the thick of this, and you've also all done it before, right? You all went through the first 4 years of Trump and then the Biden years and even the Obama years, as Professor Brown referenced, and before, and that was also a lot. I want to talk about hope, right, and how you maintain hope and cultivate hope. Mariam Kaba talks about hope as a discipline, right? Hope that doesn't just kind of come out of thin air, but something you have to work towards and cultivate. And her work is mostly in the movement against mass incarceration. But I'm wondering if you can talk about, just briefly, each of you, like how do you maintain hope in the face of, what we're experiencing right now? And I'll start with you, Jackie.
Okay.
Professor Kelly.
Thank you. Yes, I'm glad we're talking about this because I think it is so critical and so challenging. And as you mentioned, going through Trump 1 and knowing how difficult that was with new announcements every day, and now we're 11 days in and it's the same or worse, right? But I would say that for me, one of the things that's most important is being in community in these times. It's one of the reasons I'm super happy of the timing of this conference. But I have been in Ithaca, New York, working to be involved in community organizing. And as a lawyer, people of the community who are not lawyers sometimes think, as long as we have a lawyer to help us, like that will solve the problem, right? Turns out though that the laws don't really let us do that some of the time, or it's not that simple, or there's not enough lawyers. And so I have found that being in community with community organizers has helped me see all the other ways that people support one another. There are people who are like picking up groceries for undocumented folks who are afraid to leave their house, right? There are lots of things that the community at large can do that don't rely on the failures of the legal system, and to play one little piece of that conversation and to be part of that has been really inspiring for me, and also just helped me to know that this is a marathon and not a sprint, and that means that we have to play the role that we can play and be in community so that when there's a moment that we need to take a rest, there's others who are continuing to carry that forward.
I love that, thank you. I'm always telling my students to try and engage with your community in ways other than documenting their story of torture and persecution? Like, what are other ways that you can engage with the same community? Professor Brown or Rivera first? Okay, Professor Rivera.
I think working with students is really helpful because you guys are hopeful for the future. So thank you for being here and believing in our legal system and law and order. Thank you. And working with directly impacted people is very inspiring. My clients inspire me. They have hope. I was just telling somebody, multiple people, my client actually he's detained. And my students text me this morning and were like, he's gone, ICE took him, we don't know where he's at. I was like, I have to be on the panel right now, can you try to find him, right? And that gives me hope too, that the future lawyers of this, the world are also, care about people getting transferred out of ICE custody without telling their counsel, and that's inspiring to me. The family members who called us telling us, my husband has disappeared, she inspires me. My mother, who came to this country with nothing, I'm gonna cry, she inspires me. And so when I talk to her about what's happening with the Trump administration, and she's like, Mija, like, this has happened before, it's gonna happen again. And I've been doing a lot of research on the history of immigration law and the practice, and it was pretty bad back then too, right? It was probably worse than it was today. And they had hope, and we're here today. And so looking back at our history of people who have been doing this work historically for a very long time, that gives me hope. Obviously working with the organizers who have been throwing down for many years to change laws and policies, like we're not perfect, or we're not perfect, but we're organizing to change things. So I mean, that gives me hope too, and I hope to see more people organize over the next few years.
Thank you. Professor Brown?
Yeah. Pretty similar, but sometimes I have to ask Professor Heng, like, was it ever this bad? I need some reassurance. There's things that seem worse, and there's things that, obviously, when we're talking about outside of immigration law, there's so many horrible things in history that could have stopped, fighters from fighting and advocates from advocating, and we're another group of those people, so we have to draw on that for inspiration. Definitely who you work with too, the team that you work with, you get hope. You draw on your team for inspiration. Our clients, every single client, and I like what you said about their family, like so many times, my client is hopeful. Sometimes they're a little less hopeful, but then there's their family members at home that are hoping for them. And everyone around you that's hoping, you can feel it if you're actually open to feeling the hope, right? You have to be open to feeling it, because if you're not, then you're going to feel all the other stronger emotions that are out there. Sometimes when it feels like especially challenging for like a case that you're going into court and it's like the wrong judge, the wrong TA, the kind of weak case, like everything that you just feel like, oh my gosh, where am I going to get the strength? I have this mantra, and now I use it more and more even outside of those examples, where I am imagining my client that is hopeful, and I am imagining everybody at home for them and everybody in their history, and I'm imagining myself and everybody that I work with and every student that might have worked on the case, and I say, I'm not alone, you're not alone. I'm not alone, you're not alone. I'm strong, you're strong. I'm strong, you're strong. I just keep going back and forth, and that keeps me centered.
Wow, mic drop right there. So let's hear from folks who have questions, and I think maybe you're going to have to, if we're passing mics, I'm not sure. Okay, yeah, we're passing a mic, thank you. If anyone would like to add a question or a comment or a thought, we have so much wisdom and expertise in this room too. Anybody? Yeah.
Thank you. I have a ton of questions, but one thing that Professor Rivera mentioned was non-lawyers can be helpful. I'm a lawyer, I'm a graduate of USF, and I've retired from law, and I am simply appalled about what's going on. And I want to be able to use my knowledge, my experience and skills as a lawyer. Although I've retired, I'm not a current member of the bar. What can I do?
We should talk after. But I love it, and I think that you should know that the law allows you to appear in court and represent people in court if that's what you want to do and you feel comfortable. And I think that's something that may fit you because you are, former attorney. There may be other people that don't feel confident to go to court. It's a pretty scary place sometimes, right? All the time. So I think the first thing you want to do is look at the legal provisions, right? Because there's different types of roles that you can go apply for to appear in court. Reputable individual is one of them. So if you find a person, a community member that you have learned their story, have gotten to know them over the years, and they're caught up, right? And they have to go to court, you could actually go to court with them and orally tell the court, say, Your Honor, I want to appear as a reputable individual today pursuant to 1292.3, whatever, right, A3. And the E28, the form that you actually have to fill out to submit your appearance to court, actually has a box that says reputable individual, and you can just check it off, put your name in there, put it in. The thing is, I don't think a lot of judges have seen this because the data shows that less than 100 people in the last 15 years have taken advantage of it. So you may get some pushback, but that's why you should come prepared, right, with the law. That's one way where you individually can help somebody. But I think it was you, Lindsay, who said, burnout is real, right? And so I think the reason I was even interested in this topic is to think of alternatives to direct representation. Also because the universal representation model we've seen is not working, right? It works in that we're getting the campaign to get more lawyers to people, but as you've heard from the data, less than 30% people have actual lawyers. And so we need alternatives. So maybe what you do too, because of your expertise, you train then others on the legal provisions for reputable individual, and then you train them to train others, right? And maybe you train directed impacted people on how to appear for themselves or how to appear for others who are similarly situated. So there's different, you can also become accredited rep, right? Or you can renew your license too and then take on pro bono cases, but it really depends on where your skills are and how you want to spend your time.
I think too, just to answer that a little bit more, there's also amazing organizations you can plug into, right? Going out and finding somebody who's in proceedings might be a challenge, right? But I think there's so many, and I'm sure Professor Brown and Professor Hing work in coalition and community with so many orgs in San Francisco, from Dolores Street to Pangea Legal Services. We've got Cluster down in the South. There's so many organizations who are going to be needing that kind of help, and so hopefully you can follow up and plug in and connect and get the training you need. Because a little bit of knowledge on immigration law can actually be pretty harmful, so it's very complicated. And so you do want to make sure you're kind of plugged in and educating yourself. Go to the Know Your Rights trainings yourself and start to learn so that you can accurately share information with impacted people. I think there's a question. Was that Rachel? Please?
Rachel.
Hi. I was just going to maybe offer an answer. I've been telling people to study up on habeas corpus law. It's true, you can't just learn immigration. It's hard to learn habeas corpus law too, but aside from totally understanding all of immigration law, read up on your federal habeas and get some petitions ready. That's how I feel about it.
I was speaking with a family lawyer, right? 35 years of experience as a family law attorney. Okay, well, we need power of attorney. We need to put in place protections and safeguards and plans for people if they are picked up and their kids are in school. Who's going to take care of the kids? What is the plan? So some of that kind of safety planning and forward thinking.
I just want to share, I know that I'm all preaching about lawyers engaging in work, but I am very aware, and I talk about this in my paper, about the ethical responsibilities, right, we have as lawyers, totally aware of it. And it's a problem, right, for notarios, people who take advantage. And I think, again, you guys are all mostly future lawyers or connected to the law. You could set up training programs too, right, to train these community members on the law, right? So what we're doing in our clinic this semester is we're just doing teach-ins to teach people about different topics. Anyone who's interested, come on in, right? And so you can start your own training program, but maybe in collaboration with certain community organizations, because we do want to be aware that immigration is very complicated. Habeas petition, complicated, right? And so we just want to make sure we have training and preparation for folks that want to engage in the work.
And could I add one other thing? Just that, we have some universal representation programs in different parts of the country. Upstate New York, detention is one of them, but we also know that just more lawyers doesn't solve the problem. That does not lead to abolition of the problematic structures that exist, right? And so we in my clinic have also been doing limited scope, like big picture presentations, and we go into detention centers and explain to people pro se how to do their habeas. I mean, it's hard, right? But actually empowering people to represent themselves, I think, is another big piece, and that can be done by lawyers, former lawyers, and everyone else.
So we are at time for this panel, but we're about to go into a 15-minute break, so you all can continue to ask questions and speak to each other. Any announcements?
Thank you, everyone. Just give a round of applause for our panel speakers. In our second panel, I'd like to recognize our moderator, Professor Lindsay Harris. Professor Lindsay Harris is a professor of law and director of the Frank C. Newman International Human Rights Clinic. Before joining USF Law, Professor Harris served as Associate Dean of Clinical and Experiential Programs at the University of the District of Columbia David A. Clark School of Law, where she directed the Immigration and Human Rights Clinic. Professor Harris has visited as Acting Director of the International Human Rights Law Clinic at American University and previously taught at Georgetown Law and George Mason. Professor Harris has published widely in law reviews, authored numerous op-eds in internationally recognized publications, and in addition to serving as one of our faculty advisors, is moderating 2 panels for us today. Thank you so much, Professor Harris, and I'd like to give her and all of our speakers for panel 2, Bridging Domestic Policy and International Human Rights, the Future of Immigration Reform, a round of applause. Thank you.
So hi, welcome again everybody, and welcome to anyone who just joined us. It's such an honor to be here and to continue this conversation this morning. So I'm going to introduce our 3 panelists again and just share a little bit about who they are, the work they've done, where they're coming from, and then we are going to go global a little bit and talk about international human rights and where that plugs in and can it be helpful in this current moment. So I'm going to start in the middle with Shaw Drake. Shaw is a clinical supervising attorney and lecturer in law at the International Human Rights and Conflict Resolution Clinic at Stanford Law School. And before joining the clinic, he worked for the ACLU on border policy. So he really worked to defend border communities against unconstitutional, inhumane practices under the Trump 1 administration and beyond, and worked to hold Border Patrol accountable for abuses and deaths at the border, and to develop border-related litigation and advocacy strategies. So some of the kind of parade of horribles and policies that we saw under the Trump administration, Shaw was on the litigation team pushing back on that. Also prior to that, he was also an Equal Justice Works Fellow, so far we're keeping the EJW Fellowship connection strong, with Human Rights First, where he also worked on asylum policy. I haven't mentioned where people went to school, but I will do that for sure, because that's where we first met. He was a law student at Georgetown, a superstar law student. I think he won their Human Rights Prize at graduation. And we met in the asylum clinic when I was just a very newbie clinical professor in training. And he graduated with his certificate in refugees and humanitarian emergencies. So welcome, Shaw. Next, just to my left, your right, Lauren Bartlett is a professor and director of the Human Rights at Home Litigation Clinic at St. Louis University School of Law. Through that clinic, Professor Bartlett and her students provide free civil legal services to individuals in the St. Louis region and file international human rights complaints on behalf of communities in the Midwest. The human rights work that she engages with focuses on the rights of incarcerated people, immigrants, and communities facing environmental racism. She is a former legal aid attorney and co-founded the Louisiana Justice Institute. And I will highlight her Bay Area connections. She grew up in Albany, California, just across the bay, and went to Davis as an undergrad before getting her JD from AU, American University in DC. So welcome, Professor Bartlett. Last but not least, all the way on the end, Professor Helen Kerwin is a clinical supervising attorney in the International Human Rights Law Clinic at Berkeley Law. Prior to that, she was an attorney with the Center for Justice and International Law, HEAL, where she specialized in strategic litigation before the Inter-American human rights system, particularly focused on the rights of asylum seekers, indigenous communities, migrants, and human rights defenders. Human rights defenders we work with in my clinic, the International Human Rights Clinic, so that's near and dear to my heart. She has also served as a staff attorney with IMUMI, which is the Institute for Women in Migration, an NGO in Mexico City, where she engaged in advocacy, research, education, and strategic litigation focused on US-Mexico border policy, access to asylum, and also the issue of documentation, access to identity documents, particularly for dual nationals. She began her career as a legal fellow with the Inter-American Commission on Human Rights and worked in the rapporteurship on the rights of migrants, the U.S. Human Rights Monitoring Section, and the Merits and Court Litigation Section. So she has a wealth of experience in the Inter-American system, human rights system. Her JD is from UT in Texas, and we are really glad to welcome you here today from across the bay. I'm going to sit down without tripping. So we've heard a lot today in the first panel about what's happening, some of the policy changes, the executive orders coming down, some of the enforcement actions we are starting to see across the country. So we're now going to kind of look to the border, and mostly our southern border, and beyond a little, and think about US actions on a global stage. So much of what we do here in the US can shape migration trends beyond our borders, and it can also really set the tone and a sense of what is acceptable and right and legal for other countries under international human rights law. Professor Hing, in his opening remarks, for those of you who weren't here, highlighted this concept of border externalization, kind of pushing these issues beyond our borders for any refugee or asylum processing, and gave us examples of states doing that, from Australia to the UK and others, in addition to the US, right, countries that are putting these policies into place. So one kind of overarching question to keep in mind as we walk through this panel for the next about hour and a bit, hour and 7 minutes, is as the US really pulls back from international engagement in some ways, and from international human rights law standards, how can we look to the international human rights framework and standards in this time of extreme tumult? So to kind of shift into thinking about international human rights a little bit, I want to come to you first, Professor Bartlett, because the paper you submitted to the law review that will be published soon talks about using something called the Universal Periodic Review process and the upcoming review of the US through the UN Human Rights Council. Can you just walk us through what that is and how it all works and how we may be able to use it?
Yes, thank you so much. I'm so happy to be here with all of you, and that was a great, terrific first panel to set the stage, and now we're going to talk about other complicated things in international human rights law. But before I talk about the UPR process, I wanted to sort of set the stage as to why do I even want to talk about the Universal Periodic Review and using the United Nations as a place to advocate for people in the United States. My work focuses now in the Midwest, mainly in the St. Louis region. And so I really see the opportunities to advocate at the international level, whether it's the United Nations or the Inter-American Commission on Human Rights, as a way to accelerate a vision that of the world that I support, right? I believe that human rights law, human rights provide a vision of the future that I agree with, right? So it's using that framework allows my students and I to advocate for our clients in a positive manner that's mainly avoids the centralization that Professor Widmer was talking about. That's not true, 100% of the time. There are definitely problems in the human rights systems. But I think it allows for us to have sort of more freedom in what we talk about, allows us to frame things in a more positive way. And again, this shared vision of a future world that we agree with. So the Universal Periodic Review process is done by the United Nations Human Rights Council. And this is, you probably remember the Human Rights Council in the first Trump administration. Trump withdrew from the Human Rights Council. It was a big deal in 2021. This is a political body. When you're a United Nations member state who is elected to the Human Rights Council, you send essentially an ambassador, a diplomat to the Human Rights Council. That diplomat is not necessarily a human rights expert, right? Could be someone who is just chosen by the government to toe the government line. So this is more of a political body than a lot of the other human rights mechanisms at the United Nations level. And just to let you know, Biden decided not to have the United States run for re-election to the Human Rights Council. And so actually the United States is not part of the Human Rights Council right now. So that won't be a problem for this administration having to withdraw. But the United Nations Human Rights Council reviews the human rights record of every United Nations member state every 5 years. So every human rights treaty that the United Nations has, that has come into force in the universal system, in the United Nations system, the Human Rights Council actually goes treaty by treaty, provision by provision, and is reviewing each member state's record. This review happens regardless if the state is going to participate, regardless if they're going to send diplomats, mission representatives to Geneva to participate in the review. It will happen. This review happened. There has been several examples of the United Nations member states who decided not to participate, and the review still went forward. So the last review of the United States was in 2020, right? After, right before, the report was due. So there's a national report that the government who is being reviewed prepares and has to submit. And that report was prepared by the Trump administration. And so the report will be due this summer for another periodic review that will take place in November 2025. So this November in Geneva. So the government is preparing the report right now. We expect that they will submit a report and that they will likely show up to the review. That's what happened in 2020 because they know this process goes on regardless of whether they come or not, and they have some things that they probably want to say, a lot of things they probably want to say. So how does my clinic and my clients get involved in this process? So in the months leading up to the submission of the government's report, there is a chance for civil society, so individuals, NGOs, law clinics, to submit what we call shadow reports, which provide information to the Human Rights Council about the human rights record of that country. So my students and I are preparing several different shadow reports. The deadline is April 7th. We are also doing a lot of education around this process, around what the advocacy related to this process can bring. We're hoping for example, we're doing a report on environmental justice. We're doing a report on jail conditions, the jail in St. Louis, which is terrible. We're also probably doing a report on air quality in St. Louis. That one we're working with the community on that one. Might not actually happen by April 7th, but we're trying to educate folks on what the process is, what they could get out of the process. And some of the things we're hoping for are news articles in local newspapers about the fact that we're going to the United Nations with these complaints. We're hoping that the Human Rights Council We'll ask some of the questions that we are putting in our report, suggesting that they ask of the US government. And then the most important thing would be the Human Rights Council making recommendations specifically about the issues that we're advocating about. And so I can give you some examples. The paper that I submitted for the symposium is specifically about children and immigration detention. And so this is something that has been an issue, long time issue in the human rights world and the human rights mechanism process. So during the 2020 review, both China and Iran recommended that the United States stop separating young children from their families and stop incarcerating young migrant children solely on the basis of their immigration status, period, right? So you can see this is pretty political, right? It's China and Iran, right, saying these things. There was other countries that made similar recommendations, but just to give you an idea of what those recommendations look like, they're pretty broad, pretty big things. So that's what we're working on, and we, the focus of what this paper is suggesting is that the U.S. should, so for the last several periodic reviews and since the periodic review process was put in place, which it hasn't been that long. This is only the fourth cycle of the Universal Periodic Review process. There has been the United States is not interacting with the Council on the specific issue of detaining migrant children. There's these recommendations from other countries, but they're not putting anything in the reports or directly answering questions about children in immigration detention. In other forum and international human rights forums, they've made a lot of excuses, but they haven't said anything like, we eventually hope to stop putting children in immigration detention centers, or we want to work towards that. There's been no signaling of that, and I made some what I think are good arguments as to why they should at least signal that that's something they would like to do eventually, and then get advice and recommendations from the Human Rights Council, from the human rights experts at the United Nations level on how they might proceed towards that goal. We have seen for example, Trump in a 60 Minutes interview just a few weeks ago basically admitted that it wasn't a good look to separate children from their families, and he doesn't want to do that again. Instead, right, he's got this idea he's going to just deport the citizen children with their families. But even Trump is admitting it's not a good look when you have this major problem of thousands of children separated from their families, and today hundreds of children who have still not been reunited with family members. So there is a recognition in U.S. government, even under this administration, that this isn't a good idea. But putting in place policies and procedures to get there has not been something they're willing to do.
Yeah. Thank you so much, Professor Bartlett. I will say at the same time, although he may have given that interview, still on day one, part of one of the executive orders did dismantle the task force on reunifying the 5,000 plus children separated from their families, and also reaffirmed the serious prosecution of entry and illegal reentry crimes, right, under 1326. Which is what led to the family separations in the first place, right? Prosecuting people, including asylum seekers, who should not be ever prosecuted for the manner in which they entered the U.S. So Professor Bartlett has highlighted, one of the UN mechanisms, the UN Human Rights Council, and the shadow reports, and the UPR, Universal Periodic Review process. I just want to highlight a few other things, because the U.S. has not signed or ratified, I should say, an international human rights convention in quite some time. That's because it requires 2/3 consent, bipartisan consent with the Senate, and we just haven't gotten to the point where we can get that kind of Senate majority on anything to do with human rights lately. But we have signed on to some of the pretty key international conventions that protect human rights. So the International Convention on Civil and Political Rights, and that has a treaty body, the Human Rights Committee, to which we can and do bring complaints and issues. The Convention Against Torture has its own treaty body. Again, the enforcement mechanism for that treaty, and the US is party to that. The Refugee Convention, of course, we've not yet withdrawn from that. We signed on to the protocol to the Refugee Convention in 1968. And then the International Convention on the Elimination of Racial Discrimination, which is a mechanism that we saw advocates using under Trump 1 and under Biden too, to talk about immigration issues. So I want to come to Helen and Shaw and ask you, how can and have immigration advocates use, UPR, as Professor Bartlett was discussing, or these other mechanisms, these other human rights mechanisms in the past, and what might we see in the future? So maybe I'll come to you first, Professor Kerman.
Sure. Thanks first for the invitation. It's wonderful to be here with all of you today. I think Professor Bartlett's...
Can't hear you.
Sorry.
Hi.
Can you hear me now?
Yes.
Okay, wonderful.
Okay.
Sorry about that. Professor Bartlett gave a really wonderful introduction to sort of the breadth and the process of the UPR mechanism. Advocates in the U.S. have increasingly engaged with the UPR and these other UN advocacy processes that Professor Harris mentions in recent years around a number of issues, including, for example, police violence, mass incarceration, solitary confinement, death penalty, the Guantanamo Bay, voting rights, farm workers' rights, access to healthcare, reproductive justice, migrants' rights. One feature of the UPR process is actually that it is a space where the totality of U.S. actions to protect and uphold human rights are on the table, and a place really to think about working in solidarity across movements to show the ways in which these issues are interconnected. A record number of U.S. orgs went to the UN during the last UPR cycle in 2020, and my perception, at least, over the course of my career so far, is that the growing interest in international advocacy fora and the language of human rights is a response in part to the despair of the first Trump administration. This feeling of where can we go that someone will listen? Where can we go that we could win? And I think that the one reflection I have about the relevance of the UPR process and other international processes is about how the framework of human rights can help to shift the domestic conversation about social issues, social justice issues. So, for example, during the run-up to the 2016 election, we heard some politicians start to talk about healthcare as a human right and as an issue in those terms. And I think that kind of framing is powerful. Behind that, there's real law. International human rights law is law, and the idea of healthcare as a human right carries specific state obligations that are important, but it's also important in kind of general conversation to have a language that conveys a shared understanding, right, of a baseline of human dignity, solidarity, interconnectedness. So what is the UPR process good for? As Professor Bartlett was kind of laying out, the process of creating shadow reports is a process of documentation, right, of ongoing issues. The process of sitting down in the big conference room before a panel of state representatives to present human rights issues in the U.S. is a process of naming and shaming, right, before the community of states. And the resulting recommendations that come from that process, like Professor Bartlett mentioned, made by states, can then be invoked as useful on the domestic level, right? In federal advocacy, but also state advocacy, local advocacy, right? Taking the recommendations as an additional source of persuasion to say, this issue needs to change. But I think the process itself is also important as a process. And here, what I think is really critical is that if engagement in these processes are to have impact, it's because we carry them out in conversation, in alongside affected communities, right? Engaging in collective construction of information, education about the relevance of the process. If it's going to be impactful on the ground, it must be relevant to our communities that are affected by these issues. I think I'll leave it there.
Yeah, so thank you, Helen. I want to follow up with you though, Shaw. So we're talking a lot about Trump 1, right? And how this mechanism was used. UPR was used back in 2020 under the first Trump administration. I want to think about the Biden administration, right? And what we saw then with advocates turning to the international human rights system to document some of the challenges we saw for immigrants, including the treatment of Black migrants under that administration, before and now, accountability for brutality by Border Patrol, which I know is something you work on a lot. Can you speak a bit about what kinds of issues were documented and kind of to what end?
Yeah, absolutely. Well, I think you can definitely hear me. I'll start by just saying, thanks so much for having me on the panel today, and a specific plug just regarding how nice it is to be up here with you, Professor Harris, as one of Professor Harris's early students. And so for all the students in the room, just to say how incredibly lucky you are to have Professor Harris here, and make sure if you haven't taken her class or sought her out for an internship, I still count her as kind of one of a few just career-long mentors and friends. So thanks for inviting me here today. Before diving into that specific question, I think it would be helpful to kind of lay a little bit of groundwork in terms of the international impact of the orders that were discussed on the first panel. And I guess I shouldn't have been surprised, and maybe shows a bit of my ignorance in areas, but I have been surprised in the last few weeks in talking with many of our international partners that we work with through the International Human Rights Clinic at Stanford, regarding just the incredible reverberations of these changes globally, in really some really unexpected and disturbing ways. One of our partners on call just early this week that we work with in East Africa on an issue completely unrelated to migration, both had lots of questions about what this funding order meant, and explained that 80% of their country's healthcare system is funded by U.S. foreign aid, and what is that going to mean for a whole host of issues for them domestically, but also in the litigation we've been supporting them on related to a range of human rights issues. The Biden administration and the Biden administration State Department putting pressure on their court system to make decisions in several of these cases was key in actually getting the court to act. And now one very big case we're working with them on is before the Supreme Court in that country, and they basically expect that the Supreme Court will not move on a decision to potentially block a very harmful law because they are not receiving any pressure from the Trump administration to do so. Regionally related to migration, I think a couple of things. It's very likely that we'll see, and we've already seen, a lot of pressure being placed on Central American and Latin American countries to agree to collaborative deportation agreements to receive deported migrants, Mexico, El Salvador, and others, as well as safe third country agreements and things that are meant to block eligibility for asylum in the U.S. if, for example, someone has passed through that country on their journey here. We of course saw this news blip fight between the president of Colombia and Trump around receiving military flights. Those flights were turned around, and then Trump was like, we're going to smack you with massive tariffs, and Colombia was like, okay, that's scary. We'll take those deportees, just don't put them on your military planes, put them on our domestic airline planes. So, but I think you'll continue to see those type of challenges between international negotiations between countries and the United States as it relates to these policies. Another issue that we've worked on some in the clinic that I'm kind of surprised has not gotten more attention is the U.S. funding domestic deportation flights by Panama of people who have crossed the Darien Gap. The Darien Gap is the jungle between, on the border between Panama and Colombia, and in many ways one of the most dangerous parts of the journey that hundreds of thousands of migrants are forced to make from South America up through Central America. And the Biden administration was, for the first time ever, giving U.S. funds directly to a third country, Panama, for them to effectuate their own domestic deportations, people deported from Panama back to Colombia or to other countries. And so I think all of that is important kind of groundwork to kind of an overarching point, which is the increased importance of advocacy before international and regional bodies to pressure and hold other countries accountable and provide them, maybe in some instances, the political or legal opportunity, or you might say excuse, to do the right thing and push back against some of the worst impacts of the Trump administration. So many countries, and Professor Kerwin is more versed in the Inter-American system than I am, but many countries have the Inter-American Convention on Human Rights baked into their domestic law, into their constitution. Many countries have provisions straight from that convention in their constitutions themselves. And so there are real legal consequences for those countries violating the Inter-American Convention and being brought before the Inter-American Court or Inter-American Commission in ways that, of course, the United States could kind of care less and will likely not even show up to hearings. So I think in terms of really looking at legal mechanisms as an opportunity to block some of Trump's, the impact of some of these moves within the region, a real importance is going to be again put on holding those other countries to task in their collaboration with it. On the question of documentation, when I was at the ACLU, we did a ton of documentation on the impact of Trump's first order. We housed a lot of that documentation both in domestic complaints before the Department of Homeland Security. There is an internal oversight mechanism system that doesn't have a ton of teeth, but at least it's something where you can put in a complaint. It doesn't have to be like a robust legal filing. It can literally be a personal letter that is supposed to trigger some investigation and oversight by various mechanisms within the Department of Homeland Security. We filed, I think, 13 complaints within a 3-year period under the Trump administration, documenting everything from systemic verbal abuse by Border Patrol agents towards migrants in their custody to the impacts of Remain in Mexico for migrants on the Mexican side of the border that were forced to wait for their hearings in the United States. And those complaints, under the Trump administration didn't technically go very far, but it did open avenues for conversations with at least the frontline port chiefs and Border Patrol leadership within certain regions of the border that secured important protections for some people and some changes in how the broader policies are being implemented. But the other thing it did is it created a record of that time period. So once Biden won the election, we repackaged all those complaints and wrote a letter to Secretary Mayorkas and said, we've been complaining about all this stuff for 4 years, like now you're in office, now it's your turn to do something about it. And I think, maybe back to the discussion on hope from the first panel, like hoping that there is some light at the end of this whole time period, and we can actually have a different administration at some point in the future in the United States. I think documenting what happens during this period in order to set ourselves up for meaningful advocacy during future administrations where there's an opportunity for some actual technical changes is extremely important, and that's the same goes for documenting those before international and regional bodies. We at the ACLU packaged a lot of that documentation into filings before the Inter-American Commission, in testimony before the Inter-American Commission. And again, an important kind of repository for a historical understanding of what's going on in this period, where's the worst of what's happened, and therefore what do we need to focus on changing when the opportunity is there to change it.
Yeah, thank you so much, Shor, for that framing. I have distinct memories of being before the Inter-American Commission with a team of advocates during the Trump era, challenging asylum-free zones is what we styled it, which were like in Georgia and North Carolina, where courts are granting like 1.8% of asylum cases, right? It's just really very challenging to be granted asylum in those courts by those judges in general. And there was like no one on the other side of the table, right? They just didn't show up. But that doesn't mean that we don't kind of continue to use those venues and forums. But to just kind of take a step back and to zoom in a bit more regionally on that, I'm hoping, Professor Kerwin, you can walk us through what we're even talking about when we talk about the Inter-American human rights system, and then how can immigration advocates use that system, either against the US directly, or to, as Shor was alluding to hold countries who are in partnership with the US signing these bilateral agreements, receiving people who've been deported, receiving funding to beef up their own border security as well. Like, how can we hold them accountable through these systems? What are the systems and what can we do?
Absolutely. Thank you for the question. Right, so the Inter-American Human Rights System, what is it? First, where is it housed? It's housed inside the Organization of American States, which is kind of like a regional parliament of North American, Central American, South American states. It's kind of like the regional UN. It's based in Washington, D.C., and part of what the OAS has is a human rights framework. First, a declaration, an American Declaration on Human Rights, and an American Convention on Human Rights. So the Inter-American Commission on Human Rights is a sort of monitoring body. It's also based in Washington, D.C. It monitors the human rights situation in all members states of the OAS, which includes the United States, Canada.
Can we move the mic even closer?
Sorry. And Latin America. So the Inter-American Commission has, broadly speaking, two big mandates. The first, it has a series of situational or thematic mechanisms that are targeted towards monitoring of human rights situations. For example, it holds regular periods of sessions where it calls for public hearings on human rights situations of concern. Professor Harris just mentioned a kind of hearing that might be held for the Inter-American Commission. There have also been hearings on detention and private immigration centers in the U.S. There have been hearings on regional border externalization policies. These provide a forum for advocates to come and sit down on one side of the table, usually for the government to sit down on the other side of the table, and commissioners at the head, and engage in a structured discussion and a Q&A about a human rights situation of interest. The Commission also has powers to, for example, conduct country visits, to do thematic reports, to do other kinds of monitoring activities. But these are all general activities that are not case-specific. The other half of the Commission's mandate is about individual petitions and cases. So the Commission receives individual complaints for violations of a person's human rights that their government is responsible for, as well as issuing what are called precautionary measures, which are kind of analogous to a restraining order or temporary injunction that are meant to protect a person or group from irreparable harm. So all of these mechanisms are relevant, are regularly used by advocates, and have been used differently in specifically by immigration advocates in recent years. So I gave a couple of examples of kinds of hearings on detention. There are also pending cases, individual cases regarding the U.S., regarding excessive use of force by Customs and Border Protection, regarding detention of children in ORR custody as a violation of the principle of non-detention of children, and also for acts of torture and mistreatment, for example. There have been, in recent years, a very few successful grants of precautionary measures for individuals in expedited removal proceedings, where advocates attempted to stop an expedited removal process due to lack of process and risk of irreparable harm in home country that have been granted. So there are a number of different kind of strategic ways that the Commission's proceedings can be used regarding the U.S. I really agree with what Professor Drake mentioned about the use of the Commission to hold other countries accountable. Because whereas the U.S. is monitored by the Inter-American Commission, it has maintained a very consistent policy over administrations and over decades that the Commission only issues non-binding recommendations and it's not really subject to its jurisdiction. But other states of the Americas have in fact ratified the American Convention on Human Rights, are subject to the binding jurisdiction of the Inter-American Court of Human Rights, and have, as a result, take the findings of the Commission and the Court much more seriously, but also have much more extensively integrated into their domestic processes manners to implement, for example, precautionary measures, manners to implement recommendations or judgments to provide reparation to individuals. So both the naming and shaming element of bringing proceedings against these countries, as well as the eventual implementation, I think is key. And showing that kind of cooperation, collusion in border externalization measures, in accepting people who've been deported or expelled without process into their countries, in carrying out deportations from their countries, like Professor Drake was mentioning, is going on in Panama, and other violations committed along the transit route are all really important. But I want to say a word of caution. I think also, it's true. I don't think we can overstate the impact of the suspension of foreign aid. And I think we're all, this week has been really chaotic. Likewise, in my part of the world, talking with partners, talking with organizations whose grants and whose programs have been impacted, and I think we're only seeing the start of it. So I think first, it's important to name this strategy for what it is. The intention is to cause chaos. The intention is to disrupt the work of civil society and to disrupt the civic space to defend migrants' rights. I was talking with somebody a few days ago who named it as an anti-insurgent strategy. Said what they're doing is trying to quitarle el agua al pez, to take the water away from the fish by draining out the capacity in civil society to provide humanitarian aid, to provide legal defense, to engage in advocacy. That's also a strategy to implement the vision of society that the Trump administration has. And it's, I think that the fight is difficult, but we should also be very attentive to the sort of draining civic space inside the United States, right? And the attack on civil and democratic institutions as a very concerning background issue that's on the march. So what does this have to do with the ICHR? Professor Harris mentioned that during the last Trump administration, the government stopped showing up to hearings at the ICHR. I think we can certainly expect that they will not show up to hearings during this administration. But also a really significant portion of ICHR funding comes from U.S. congressional appropriations, more than half. So again, part of the attack on human rights is the attack on the institutions that uphold them. So none of this means that advocacy before the ICHR isn't useful, but it means that the use of the space should be strategic. And it also means that when you go to a space like the Commission is never your only audience, right? You're also talking to the public at large. You're talking to government officials, again, whether federal, state, local. You're talking to social movements, right? And using these fora also as a space to articulate and engage in advocacy towards other publics.
Thank you so much, Professor Cowan. Yeah, I mean, that made me think of so many things, but I have in my head that really powerful image of the fish without the water. We're all going to have to be really creative little fish, right, who work together to find new water, to find ways to swim with not as much water, or different ways to swim, to work together and do this. So thinking about some of what you highlighted, and some of it is the kind of US exceptionalism when it comes to human rights, which makes all of this really challenging. I want to spend the rest of our time, before we get to questions, just talking a little bit through some of your real areas of expertise. So I'll start with you, Professor Bartlett, just to follow up on the discussion that you began. Your paper for the symposium focuses on international human rights law as it pertains to the detention of immigrant children in the US. Can you talk a little bit about some of the conclusions that you draw? And we saw this under the Trump administration: family separation, extreme detention of children. The conditions got really bad, haven't improved too much. But what might we expect in the next 4 years? And can international human rights law put any guardrails on that? Like, where is the hope?
Yeah, those are great questions, and I'm really hoping that that there are some guardrails that can be found. So I think a few of the things that my conclusions in my research are: one, the detention of children for migrant children solely based on their immigration status never ceased under the Biden administration, and the separation of families never ceased under the Biden administration. There's lots of great reports out there that you can find, some by law clinics and NGOs, that really detail the terrible conditions faced by families and by unaccompanied minors in detention. Large numbers, thousands and thousands and thousands of children. And so I think that's one of the biggest things, is that there was a lot of rhetoric the Biden administration put out in the world about halting family detention, halting the detention, and it was never stopped. And we're going to see it expand under Trump. Trump too. No matter what he's saying, right? And so I think I'm trying to go back to basics about scientific evidence, scientific studies about detention of children, separation of children from families, but just detention of children and the long-term harm caused just by children being detained, not having freedom, right? Let alone being detained in ice boxes, let alone being not provided educational services or health care from serious injuries and illnesses, right? But just being detained causes long-term, lifelong harm. In the United States, in family law, we have a standard of best interests of the child when we're looking at custody or abuse and neglect cases, and this has never been transferred, or however you want to say it, to immigration law and talking about children. We're not, especially detention of children. And at the human rights level, the United Nations, Office of the High Commissioner of Human Rights, a large number of special rapporteurs, which are human rights experts on particular subjects, have all called for the end of immigration detention of children because of the documented harms. The Inter-American Commission also has called for the end of immigration detention of children. And so I think bringing all of that together and keeping the drumbeat going and keep talking about the harms being caused to children and families. I think I wrote another paper that was End Immigration Detention Period, but I decided to go specifically to children since there was so much out there specifically about children. I come from an abolitionist perspective, or that's my ethic. So really don't think that it should be just focused on children, but if that gets some attention, especially in the human rights world, makes it so clear that's what's going on. So I think, in terms of guardrails, naming and shaming is a big part of the strategies that we talk about in the human rights world, where there may not be applicable, enforceable law, especially here in the US. And so really trying to get attention on these issues, documenting, putting out reports, getting news media to focus on this issue is one way of having some sort of guardrail. And I think, again, as I said in the opening part of my remarks, really thinking about trying to focus on a vision of a world we want to see, and if hopefully that includes no detention of children, but hopefully at some point no detention, immigration detention, period.
Yeah, I think you're right that focusing on children sometimes can be such like a galvanizing force. I think I worked on family detention issues under the Obama administration and would be at protests in DC on the streets, and we would have like 15 to 30 people at the protest, and we would do a march from DOJ to the White House and have some of the formerly detained families come and hold signs and protest, and no one was there, right? People weren't paying attention. And then when there was family separation under Trump, everyone was like, what? We're detaining families and children. And suddenly our protests gained some traction. There were national protests all over the country on these issues. So I think there's a lot to be said, right, for those images of children being ripped from their parents' arms at the border. I want to dwell on the border and come to you, Professor Drake. You've done so much work thinking about Border Patrol as a policing agency, as the giant law enforcement agency that it is. Can you talk about your work in that arena and how it intersects a little bit with this human rights framing?
Yeah, and I want to make sure we have time for questions, so I'll keep it super brief. It's also a pretty technical and long-winded area of law to go into, but the long and short of it is that Trump's deportation force already exists. He doesn't need the military. He doesn't even need that much more funding from Congress. Customs and Border Protection is the nation's largest law enforcement agency, has over 60,000 law enforcement agencies as part of it. Among those are about 20,000 Border Patrol agents. This is where I always have trouble talking about it because it is so kind of complicated, but some of you may have heard of the 100-mile border zone. There is this zone that's defined as 100 air miles from any international boundary. So we're in the 100-mile zone right now. Groups for a long time talked about the 100-mile zone as a constitution-free zone where Border Patrol is granted all of these extra constitutional authority to do things that police otherwise in other parts of the country couldn't do. Advocacy groups, and we did a lot of work on this at the ACLU, including like pulling a lot of our own material offline, try to correct that. Border Patrol is not free to do whatever they want within the 100-mile border zone. The Constitution and the Fourth Amendment still applies to them. They have some narrow exceptions to that. The Supreme Court has said they can consider race as one of the factors when they're articulating a reasonable suspicion to, for example, pull someone over to check their immigration status. They're allowed to set up permanent internal checkpoints and ask every vehicle going past the checkpoint if they're a U.S. citizen. Normal police couldn't necessarily do that. But outside of those kind of exceptions, the Constitution still applies to them, and it's important that we defend that to protect against this idea that they're this agency that can kind of do whatever they want, even close to the border. The other piece to that, though, is that the 100-mile border zone really doesn't matter when you look at where Border Patrol derives its actual legal authority as an immigration officer. So there are many cases before courts across Texas and Arizona and California where Border Patrol pulls someone over way more than 100 miles from the border, particularly in Texas, 200, 300 miles even from the border. And the court goes through this lengthy analysis of like, was there a reason to believe that the vehicle was like, had recently crossed the border 300 miles ago? Are there these other factors at play that say that, you know, support the idea that Border Patrol had some reasonable suspicion for pulling this car over? And courts in many cases have said, yeah, okay, the car was traveling on this highway that comes straight from the border, it had all these characteristics, add in the racial profiling, that's okay under the Supreme Court jurisprudence, and you get to a point where courts are like, all right, Border Patrol, you can pull over someone 300 miles from the border under these pretenses that you think they're coming from the border. So all to say that Border Patrol's authority as an enforcement agency and CBP officers is nationwide. We saw that really dramatically in the summer of 2020 around the George Floyd Black Lives Matter protests. CBP agents were deployed all across the streets of Washington, D.C. If you remember the kind of infamous images of law enforcement officers with no clear label of what agency they were with, kidnapping people off the streets of Portland, Oregon. Those were Border Patrol agents. They were from their BORTAC team. They had been deputized to protect federal buildings. I have it in my paper that I've written about this. There's tens, I forget the number. There's a lot of federal buildings everywhere in the country, and so you could deputize this agency to protect those buildings in basically every city across the country. Border Patrol sniper units were at George Floyd's burial service outside of Houston with the authority to use deadly force, perched on top of buildings around a cemetery where the family wasn't even a public protest or a public funeral. It was like where the family was actually burying George Floyd. And so yeah, the agency has really, really far reach in a way that I think most people don't fully recognize, and even a lot of I think people who work on these issues don't fully understand kind of the way the law interacts with that agency. And so, yeah, I think it interacts with obviously this issue in a way that this is the agency that's primed with enforcing some of the worst of what is happening, including arresting people who are coming across the border and applying law to them. So.
And with very low kind of training, expectations, credentials required to enter that force.
It's a whole other panel about Border Patrol.
And internal accountability, kind of a joke.
Yeah.
So last question for the panel before we open it up, and I want to just make sure we touch on this topic to kind of surface that expertise. But Professor Kerwin, you're publishing a paper with the Law Review which focuses on climate migration. And climate policy in the US has, of course, shifted again in the last 10 days as we saw Trump withdraw again from the Paris agreements. And at a time when we're seeing widespread wildfires and other climate disasters, climate-related harms, can you just share a kind of top-line brief bit about what your paper discusses in relation to climate refugees?
Thank you for the question. And yes, I'll try to be super brief to leave
time.
Let's be kind for questions. So my paper addresses the question of how can we improve access to protection for people displaced by climate, by the impacts of climate change. We know that in coming decades, it's projected that millions of people who otherwise probably would not have had to leave their homes will have to leave their homes due to these impacts, and some number of them will probably leave their countries. So this is a frame for talking about, the need to increase access to protection across the world. This is not a particularly hopeful environment for making these kinds of legal changes over the next 4 years. I think there are many barriers in the United States, but what my paper does is draws on some points of international law that have also been very well integrated into the law of many foreign countries to say we could think differently about the U.S. refugee protection system. It focuses particularly on the non-refoulement principle. Non-refoulement is a French term. It means non-return. And this is a principle that requires states not to return a person by any means to a country or territory where that person's life, integrity, or liberty would be at risk of degradation. So folks who know something about refugee law, and as Professor Brown mentioned in the first panel, will have heard in that definition that there's no nexus requirement in that definition. There's no requirement that the risk to life or liberty be on account of race, religion, political opinion, and so on. But for anybody facing a serious risk to life or limb. And so what my paper draws out is that this principle of broad protection is really well established in international law. The Committee Against Torture, which you recall the U.S. is party to the Convention Against Torture, the Inter-American Court of Human Rights, the UN Refugee Agency, which is the specialized humanitarian but also legal agency on the Refugee Convention, among others, have all held that it's a jus cogens norm. Jus cogens means non-derogable. It means there's never an excuse for a state not following it, even if they're, regardless of whether the party or not to a certain convention, the community of states has decided this is unacceptable. And internationally, international bodies and foreign courts have found that, in fact, returning somebody to a situation where they would not have access to the medical care or the medicines that they need to live a life with dignity, or would be subject to other kinds of conditions that would violate their right to life or right to life with dignity, are reasons not to return them to danger. So facially, the U.S. does not incorporate this standard into its refugee law. The U.S. has a subsidiary protection regime, so after you consider whether somebody's an asylee, you then consider them for what's called withholding of removal or withholding of removal under the Convention Against Torture. These kinds of subsidiary protection are very, in some ways, more complicated than arguing an asylum case itself. Procedurally and factually, there are additional requirements that you have to prove. If we wanted to advocate to bring U.S. law in line with international standards, this subsidiary protection regime would have to be reformed. So again, I don't speak about or bring this issue to the table based on the likelihood of this happening in the next 4 years, but because advocates and aspiring advocates should be clear that this is not a wild idea. All EU states, Norway, Finland, Switzerland, Australia, Mexico, many Latin American states, incorporate this protection into their law, and the U.S. is behind the curve. So as the impacts of climate change in coming decades increase in instability in the world, but also as people flee situations of gang violence, persecution, generalized violence that may not fit or may not easily fit into the refugee definition, but that threaten their lives, the need to expand the access to protection is urgent, and this is an available pathway to do so.
Thank you, Professor Kerwin. So I think that your paper may not feel super realistic right now for U.S. law and policy to change, but I was also, I keep hearing rumblings of we need to have our own Project 2025, right? Project 2045, people are starting to talk about. Like, what would the future look like? What would we envision? How can we imagine it and kind of put things in line, like, set up the ducks in a row to make it happen. So it comes back to that hope again. So we've heard a really wide range of topics, right, that we've covered in terms of migration and human rights. So I'm hoping to open it up in our last 10 minutes to hear any questions or comments. Again, so much expertise in this room, so we'd love to hear from you. It's heartening to see so many of you here. That must have raised some questions somewhere. I'm seeing some tentative hands almost rising. I'm a professor, I can wait. Or I'll just start calling on you.
You can cold call.
Yeah, cold calls, yeah. Yes, is it Frederick? Is that right?
Yes, this morning's been mostly focused on the law and how it's implemented or not implemented. What is going on the ground in the immigrant community and the undocumented community? Are there any organizations organizing drives or anything like that? Are immigrants taking action independently on their own to try to stop any of this?
That might be a question Professor Hing feels like chiming in on. You want to talk about what's happening locally at least?
Well, there's a lot happening across the country, not just locally. And I'm sorry, our guest speaker this afternoon, I'll encourage to talk a little bit about this. But absolutely, from dreamers to their parents, to parents of U.S. citizens, to asylum applicants, you name it. I mean, those organizations exist, and they have a lot of allies. Sometimes they call upon us, sometimes they don't. But they're not taking this sitting down.
Okay. Dalia? Oh.
Thank you for being here. Professor Drake, you mentioned the United States' role in funding deportations in other countries like Panama to Colombia. And one of the things that we're currently noticing with this new administration for folks who are recently detained by ICE is instead of being asked whether they fear a return to their country of origin, they're being asked whether they fear a return to Mexico. My question for you is, and this is like a bigger question I guess for all of y'all, is what international human rights law mechanisms do you see viable or possible to hold the United States accountable to sending people back, one, to countries that they're not even from, and two, like, to countries that they genuinely fear? Yeah. Thank you.
Yeah, I mean, I'll keep my thoughts brief, and others, I'm sure, can chime in as well. But yeah, I think back to kind of my one of the main points was around just the focus being on Mexico as opposed to the United States. So Mexico has to agree to accept their own nationals through deportation, as well as definitely they have to agree to accept other countries' citizens back into Mexico via those removals. And so I think the inter-American system and Mexico, litigation within Mexico, there's organizations within Mexico that have brought a lot of litigation before the Mexican domestic system, challenging Mexico's role in a lot of Trump 1 policies, and I'm sure we'll challenge it again through that system during this round, and the Inter-American Commission and Court to put pressure on Mexico to not allow further removal of those non-Mexican citizens back to Mexico. I don't know if others have.
Yeah, I mean, I think that you were in my class, Dalia. Some of the mechanisms that we've talked about are viable and make sense. Unfortunately, the Refugee Convention has no treaty body that enforces it in any way, and that's why we see folks, individuals or states, looking to the Human Rights Committee, looking to the CAT Committee, and I think a big avenue is the Committee for the Convention on the Elimination of Racial Discrimination, because so much of this goes beyond nationality and is about racial profiling, and that's just going to continue to kind of unfold in the coming months and years. And so I think that we've seen that body being used in different ways by immigration advocates, and I think we can continue to see that. It's very challenging to, if the deportation has actually been effectuated, to then keep in touch with those folks and find them and bring those claims. But I think that's why we need to think a lot about kind of cross-border advocacy. I know that's something you're passionate about, in communication, so that we can track people and understand what is happening, and empower them in any way we can to push back on these abuses. Any other things to add? Okay, we got 5 minutes, so maybe another question or two.
Yeah, thank you everybody, all you guys for all this information. Could you comment a little bit about rapid response teams, and I know that's a big question and the effectiveness of them in the last Trump period, and how you're looking at it this time around?
Yeah. Anyone want to? Are you talking about kind of community rapid
Yeah,
response
community,
teams?
yeah, community rapid response.
Yeah. I mean, my personal take is they're going to be critically important, and it might also be something that Professor Hain wants to talk about. But,
Yeah, sorry, actually, and Bruce, I meant to tell you when you asked that question earlier, the third panel, Francisco Ugarte, is going to talk about the local, but there are rapid response numbers in every county of the Bay Area, and again, we'll talk about it later, but they are effective. The clinic is part of the San Francisco and San Mateo and Sonoma County rapid response programs, and so there's a pledge that an attorney will show up when it's a real ICE incident, but that's been a problem. The vast majority of the calls have not been verified, that ICE is not involved, but that's part of the hysteria that we're trying to battle.
Thank you. Any other questions for this panel before we break for lunch?
I have a question for Professor Drake. I'm from Texas, and I'm an immigration attorney focused on policy work. And I was wondering, you mentioned doing some work in Texas. Have you been watching or been involved with like Operation Lone Star, specifically looking at the SB4 state deportation law and how law enforcement can order people removed as quickly as within 48 hours for those who aren't familiar with Operation Lone Star? So interested if there's been any work done there.
Yeah, yeah. With the time we have, maybe we can also. I'm happy to talk offline too more, and also happy to be connected to some of my former colleagues and others who are working actively on that issue right now. But yeah, I spent the last 5 years of my life living and working in El Paso, Texas, where a lot of Operation Lone Star has been. A lot of resources have been focused, as well as in the Rio Grande Valley. And yeah, I mean, it's horrendous. You see it physically along the border with like barbed wire and state reserve troops trying to actively repel people from crossing the international boundary line. In El Paso, there's a huge issue of DPS, Department of Public Safety, state police officers conducting extremely dangerous vehicle pursuits through communities, including past schools and hospitals, and causing just a constant flow of crashes and deaths as a result of chasing vehicles, which in a way that is actually now against beyond what Border Patrol itself can do after they changed their policy just a few years ago. So a ton of impact on that way. There's lots of litigation happening on it still. A good friend of mine is working for El Paso County, and they've sued Governor Abbott around it. So obviously Governor Abbott is more empowered now than ever to go forward 100% with his vision of state enforcement, and we'll see how it plays out in the courts.
Yeah, and on this panel we kind of like zoomed out globally and internationally before we zoomed in, but this afternoon we're going to have a bit more of a focus on local advocacy and pushback, and honestly the important role that states and cities and counties, municipalities can play in pushing back on everything that the federal government is rolling out. So I think we will stop there because we have 1 minute, so not really time for any new questions, but do connect with us, and thank you all so much for being here. It's really heartening to see everybody in the room today. Let's give our panel a round of applause.
We are now going to break for lunch next door. We will have 1 hour for lunch, and then we will return back here for our third panel and our keynote speaker. I do invite folks to sit with people you don't know, meet new students or practitioners or attorneys or organizers here. That is the point of events like this. So meet someone new, find a table, grab a sandwich and salad, and then return back here at 1 p.m., but you can eat over there. Please find your seats. I'd like to call Professor Hain back to the stage as the moderator for our last panel, titled Immigration Law in Flux, Navigating Criminal Penalties and Agency Power. Thank you.
Thanks, everyone. Wow, a lot of you stayed. Terrific. Before we get to the panel, I want to acknowledge Eric Cohen, the Executive Director of the Immigrant Legal Resource Center. Where are you, Eric? And the rest of the the ILRC is the financial sponsor of the symposium. So thank you. It's my privilege to interview the panel before we get started. We're going to segueing into the criminalization of immigrants, and I'll introduce them first, and then we'll go to the first speaker, Stacy. Stacy Caplow is a leader in the clinical legal education field. That's where I've known her for many years, and she has been president of the Clinical Legal Education Association and served on the boards of editors of the Clinical Law Review. She teaches criminal law and several immigration courses at Brooklyn Law School, and she co-directs the Safe Harbor Project. As a member of a project to promote sustainable reforms in higher education, she spent time consulting at law schools in Armenia and in Georgia. So thank you for joining us, Stacy. The next two people I'm going to introduce, I'm not even going to look at their bio because I don't know what it says, and they're probably very long. Jennifer Chacon is one of my failed projects.
Thanks.
For years, when we were colleagues, I tried to encourage her to learn how to play the guitar. I even lent her the guitar. I might have even given you 1 or 2 lessons. And so she sheepishly one day brought the guitar back to me, and there it was. I'm not even sure your fingerprints were on the guitar. But Jennifer is a co-editor of our casebook, and she's a professor at Stanford Law School. Francisco Ugarte, who is the director of the immigration unit at the San Francisco Public Defender's Office.
You never
My
gave
question
me a guitar.
to you, Francisco, is: did you surf this week? Were you planning on it this weekend?
I didn't, but I've been
Closer to the microphone.
I didn't, but I've been watching looking at the forecast, and it's been fantastic surfing all week.
This
but I missed
guy
it.
surfs off of Ocean Beach in San Francisco. How many times a month would you say you do that?
I try at least once a week. So.
Yeah, wow, okay, and as many people
Insane.
know, I don't swim. And so, but prior to Public Defender's Office, Francisco was at Dolores Street Community Services, and he went to school at CUNY.
CUNY, yeah, that's right.
Anyway, so we're going to get started with Professor Caplow, who's going to talk about deportation of so-called criminal immigrants. You can come here to do a clicker, or you can sit there, and they can click for you.
Is there a clicker on the podium?
Okay, here we go.
I'm going to stay seated if that's okay.
Sure.
Okay, great. See if this works. Good morning, or afternoon, everybody. Glad to see people stayed after lunch. You know, often there's a dropout, so I think that's a tribute to this morning's panels and how informative they were. So I was happy to see Francisco went to law school at CUNY, so there's been a lot of California representation here today, but now we've got the other coast of immigration semi-sanity represented on the panel. I just want to thank the organizers for inviting me to come here, and also to really give a shout out to the editors of the journal, and particularly to Shannon, who is the best editor ever, wherever she is. And also to just say thank you to my co-panelists for putting up with what is going to be a lot of my pipe dreams. Like everybody else here, we've all spent the last 10 days kind of reeling, and this morning we heard a lot, the inventory, which was not even that thorough, of all of the parade of horribles that is already happening, and the tectonic changes, and everybody's nerves are cracking. I started out becoming part of this panel because I had thought about how to use state law to subvert or circumvent immigration consequences for people convicted of crimes. But in a funny way, that almost seems like a naive topic right now because there's so much else going on. But what I guess I saw as a way of subverting or ameliorating some of the harshness of how people who are convicted of crimes are affected by immigration law, now maybe I can see it as an act of resistance, because that seems to be what everybody has to be doing right now. So, the allocation, I have to say it's sort of funny that the exact same examples that Professor Hing used this morning are ones that, of course, are kind of obvious and I picked up on as well. But the allocation of responsibility for immigration enforcement between federal and state governments has always been there. I remember opening up the casebook for the first time and reading about, there used to be head taxes when people landed at the harbor in Boston or whatever. But the federal government really didn't want to put up with that. And, day 2 or 3 of immigration law course, we learn about how federal government has preempted immigration enforcement. So who's allowed in, who's expelled is a federal question. But, over the years, we've certainly witnessed many efforts on the part of states to get involved with this. And there's no shortage of efforts going on right now. Let me just see if I can click. That, by the way, is not a map about immigration. That's a map of election. But I think what you end up seeing about some of these maps is there's an identity between the blue states and states where there's some form of immigration, pro-immigrant legislation going on. So there's no shortage of efforts to have states get involved. We know a lot about Texas. I was happy to see that Iowa enjoined its efforts to criminalize unlawful presence. And then the chilling example of Mississippi with the bounty hunters who are going to be rewarded by $1,000 for every person that they've helped to get deported. And then even the new Lake and Riley Act, which sort of gives away power to the states. So sue, you can sue us if we don't do a good job, says the legislation. So there has always been this back and forth of sort of ping pong, seesaw, states wanting to grab more immigration power. If you don't mind a little bit of 5 seconds of a personal journey. So I started doing immigration law, mostly doing humanitarian, largely asylum. But then we have an evening division at our school, and we mandated clinics. And so for evening students who are working full time, it was a little difficult to come up with clinical opportunities that work for them. So I switched for a while to doing pardon applications for individuals who were facing deportation because of their criminal convictions, because it became sort of a manageable project for evening students who could only come into school at night, and it didn't involve court. So what that I had never done crim-im, but what that taught me was that there are all of these people out there who are facing deportation for things they did a long time ago often, who came to this country as children, often as asylees or certainly as lawful permanent residents, and who had kind of led law-abiding lives that they messed up a little bit along the way. And many of them were currently in removal proceedings. My first client literally had already had her petition for review denied by the Second Circuit. So they were in serious jeopardy. And needless to say, a pardon is not an easy thing to get. So this was a real it was a real challenge, but it was very similar in a lot of ways to asylum in trying to narrate the life of a person who deserved this kind of generosity. I want to point out that over the years we have actually gotten 3 pardons, but that those were hard fought, and we still haven't gotten any from the federal government, given the fact that so many people were recently pardoned both pre and post new administration. But none of my federal defendants, all of whom were drug mules, managed to get pardons from President Biden, disappointingly. Anyway, all of these people had been in the United States. They were all LPRs. They'd all been here for a long time. And they had strong equities, but had this usually one conviction that stood in their way of, of leading a life free from any kind of fear of ultimate removal. And my students would always ask the question, who benefits from deporting these people? And, who's hurt by their remaining? And it was really hard to answer that question. So I started to explore, is there some way that state laws can be transformed in some way that could help people avoid the convictions? I'm sure maybe not all of the students in the audience, but certainly anybody who's an immigration lawyer in the audience knows how difficult it is and how constricted immigration law is for people who are convicted of crimes. I mean, there's basically no discretion, whether it's in the criminal world where there used to be a way for a judge to say this person shouldn't be deported, or whether it's in the immigration world where rehabilitation doesn't matter, even if you've got a conviction. And then all of the changes in the law where the number of deportable offenses increased dramatically, where the definition of a conviction was tightened up so much that people, could hardly avoid being, having their convictions be considered convictions for immigration purposes, even if they were expunged or things like that. And then, of course, Padilla came along to awaken everybody to the idea that there was something going on when people were facing criminal convictions that had long-term consequences for them. Sometimes these consequences didn't come to fruition until many, many years after their whole criminal history was finished, when they kind of started their new life, and they were suddenly faced with some sort of removal proceeding. But Padilla, obviously Padilla was an important major sea change in people's attitudes about, and judges' attitudes, and the law's attitude about what people should know about when they take guilty pleas. But Padilla didn't stop people from getting deported. And I'm lucky enough to work in a jurisdiction where our prosecutors very sort of immigrant friendly, and I'm sure there are some prosecutors' offices in California that are similarly immigrant friendly. But Padilla doesn't guarantee that somebody's saved from prosecution. So coming from New York, there's a lot of pro-immigrant activity. New York is sort of the birthplace of deportation defense rights that that our government has funded removal proceedings for people who are in detention, and having that kind of a legacy. And then there was a statute that was felicitously entitled "One Day to Protect New Yorkers," which I then learned, I thought this was the greatest statute, reducing the penalty for misdemeanor by 1 day avoided certain types of deportable crimes. And then I learned it was old hat in California. They'd already done that. I guess I'm sort of preaching to the choir here, that because California law is, of course, exemplary and way ahead of the game. And actually, there was a recent article that was published by Vanjie Abriel called "The California Way, an analysis of California's immigrant-friendly changes to its criminal laws," in the Howard Law Journal. So if anybody hasn't read it and needs to learn about it, it's a great place. So, what did I discover in looking at the laws around the country? Well, obviously California has staked its own claim to being well ahead of the game. But there's sort of three takeaways that I saw. One was basically early intervention in the criminal process. So to avoid a conviction altogether, so to have some form of discretion built into the system where the balance between law and order and immigration justice could be struck, that thinking long term, a person could avoid actually having a conviction. Obviously reclassifying crimes like the misdemeanor bill, or having some sort of pre-conviction diversion that was designed to work with people who had immigration consequences in the future. Post-conviction intervention, codifying certain forms of relief that would pass muster in immigration court as being relief based on a defect in the proceedings. My personal favorite was pardons, where convincing governors that having programs specifically designed to assist immigrants avoid criminal consequences, and then putting into legislation some of the constitutional remedies so that Padilla, the fact that Padilla is not retroactive in most jurisdictions could possibly be changed. Obviously, all of the sanctuary bodies of ideas were part of this picture, and the lack of not cooperating with federal law enforcement efforts, as well as funding from state legislatures for Padilla units or for deportation defense of other kinds. So then I asked myself, well, what motivated California? What motivated Oregon? What motivates New York and Illinois to have statutes like this? And the best explanation I kind of came up with was the idea of interest conversions, which is a concept that has to do with sort of racial justice, but the idea is that the interests of the minority, in this case immigrants, coincides with and overlaps with the interests of the majority. And what I saw was interest convergence in this area was really just the idea that people's communities were being potentially destroyed. Certainly families could be destroyed. The economic base could be destroyed by deporting people. And the people in those communities, in those religious institutions, in those educational institutions might have feelings about this consequence to their communities. So, I thought, well, when you read about some of the legislative history behind some of these statutes, there's a lot of language about protecting immigrants from unjust outcomes. So I guess the idea was to put power and discretion back into the hands of the community in some way. And for those of you, probably know very few people in this room were practicing at the time when the judicial recommendation against deportation was law, but that basically was a way of saying to criminal judges, you know this person pretty well. You know what this person's accused or convicted of doing. You know what their families are like. You have their probation report. They've been in front of you. Exercise discretion to determine whether they really deserve to be deported. And so, maybe people in this audience have other explanations for why this has happened, but that's the explanation that I came up with. So I wrote an article about it. And, again, for people from California, it probably didn't tell you anything you don't already know. But, so that's today. And I feel like a lot of this is, where is this going? Is there any room to argue that states with all of their well-known hostility provide us with any solutions? So, immigration reform has always been kind of magical thinking. People who talk about abolishing ICE, opening borders, expanding the refugee definition. These are things we all think about, we all hope for. We heard about ideas this morning, but, it doesn't happen easily. So I thought, there were maybe some hopeful signs, but where will change come from? And one of the thoughts I had was there are, looking at the darker blue coloring here, those are the states that have immigration enforcement, that have enacted immigration enforcement statutes. And you can see that there are, a pretty fair number of states which have pro-immigrant statutes. And I'm encouraged by the fact that 22 attorney generals joined together to sue on the birthright citizenship. That's almost 50% of the country. So there's maybe some spirit underneath all of this. So there's some crazy ideas. So one idea, by the way, this is the bad map. the dark blues are the anti-immigrants. So some of you may have read this article that came out in the New York Times a couple of weeks ago about a guy in Georgia who is a DACA recipient, and he has lived in Georgia since he was a child and married a woman who's not an immigrant and whose family is not an immigrant. And his father-in-law, the article is about how his father-in-law voted for Trump. And his father-in-law said, we voted for mass deportation. That was a great idea, but I didn't realize it meant you, about his son-in-law. And so this article was basically the father saying, you deserve to be here. And the son-in-law said, well, you should have voted differently. And they're struggling to find, and I guess they should probably consult with the clinic at Cornell to find ways to stay. But basically, this is an awakening for this father-in-law. And maybe if you multiply that, you'll see that there are some other options that could happen. So I figure, like, when you see the labor force impact, if it turns out that some of the predictions come true about the loss of workers in various essential or very important industries, people will have a reaction to that. Even if people see ICE agents, there's a nice PR effort where you're wearing an ICE vest or whatever, and it looks very law and ordery, but when it happens to your next door neighbor, maybe that will start to make an impact on people. And there are all these doomsday predictions that I just pulled a bunch of headlines from different reports about what mass deportations mean. So the question is there anything constructive out there? And I'm just going to mention one thing that I came across that could be an example of interest convergence. I feel very naive in a lot of ways about economic migration and sort of the abuses or the uses of bringing people into this country to do labor. But one idea I encountered was an idea of state-sponsored visas, where in thinking about my theme of can states do anything good, where states actually look at their own needs for labor and apply for visas for workers. And the legislation that's been kicking around for a while, which has basically gone nowhere, allows for for undocumented as well as people who are here in various forms of temporary work visas to be employed under a temporary visa for a period of time, similar to the H visas or something like that, but that the state, rather than the federal government, would be able to set priorities for their own communities and would be a way perhaps to preserve community, preserve family, and preserve sort of the basics of their stability. So I don't know, I just was struggling to find some hope, and that seems to be the theme of the day. And don't want to end on a note of pessimism or excuse me, or of negativity. But look to the states that do have immigrant-friendly legislation, and look to the people standing on the steps of City Hall. Was it the other day protesting their commitment to remaining a sanctuary city, and having the courts hopefully be as potent or as strong a force as they were during Trump 1, as well as the Administrative Procedures Act actually working, and lawyers in Chicago who tried to sue because their free speech, they backed down, but they backed down heroically just today. And then of course all the students in the room and all the lawyers in the room who just need to take a deep breath and remain committed. I think those of us who've taught clinics over the years know that it's a place to inspire people to want to do this work. And I have many students who actually have followed the path, which makes me really proud of them and of me for inspiring them, like as Lindsay does to her students, and we all do. So thank you for just putting up with my wheel spinning, and let's hope that the states that are strong remain strong, and the courts remain bulwarks against the states that are trying to do the wrong thing. So.
So, Stacy, a couple of your remarks reminded me of, it's interesting on the state action thing, that a few years ago when Orrin Hatch was still in the Senate and alive, he actually, under his leadership, Utah actually came up with a compact that created an immigration zone based on the economic needs of different parts of Utah. And it was presented to Congress, but it didn't go anywhere. But that's kind of along the ideas that you're talking about. And yeah, I was around when there was possibility of doing judicial recommendation against deportation, which was deleted, I guess, around 1990. And something that you didn't mention was, that you alluded to, was prior to 1996, even aggravated felons could apply for a waiver. Which leads me to a question that I want you to take a stab at answering. What you've written about in your article is primarily about the deportation of lawful permanent residents. Mm-hmm. And you point out that that we're talking about people who have been convicted of crimes, often labeled aggravated felonies, who have already served their time in prison. It's not about avoiding their prison sentence. They so-called paid their dues to the state, and now they're out, and then ICE takes over. So what do we gain? What does the country gain by deporting somebody who's already paid their price in the criminal justice system?
Right. Well, I can't answer that question because the answer, for some people, probably they deserve to be deported if depending on their crime and who they are and all of that. But I don't want to burden with the examples, but some of the people that I represented were put into removal proceedings 10, 15 years after their conviction. And it's easy to answer your question for those people, nothing, because they've gone on to...
That's the answer I was looking for.
Exactly. And, some of them were put into detention because they got picked up for some minor offense and the case got dismissed, but ICE came into the picture and they were in detention for months and months before they were finally bonded out and then put into removal proceedings, and it made no sense to try to deport them. So, but if you don't mind, and then I want to, of course, shut up, but I struggled in writing this about sort of singling out LPRs for special consideration, largely because, as sort of citizens in waiting, they're often here, they often have long community ties, they've come here through the regular processes, they haven't jumped the line and whatever. But this sort of good immigrant, bad immigrant dynamic that came up this morning, is not one that I want to necessarily support, because so many people, there was a thing on the news I watched last night, a guy was deported after being here for 19 years, and his whole family was here, but he had no immigration status. So that person isn't, in my mind, any different from the LPR in terms of why they should remain, but still the LPR sort of has those extra benefits that commend them. So.
Excellent point. So Jennifer, you've written a lot about the crim field. Did you coin the phrase?
No, I did not. I coined it.
I wanted to give you credit. But I think that what you're going to talk about is kind of an extension of what Stacy started in terms of state and local, other sub-national jurisdictions and their response to these types of moves by the federal government.
Yeah, so, and I will try to be brief. I always say I'll try to be brief, and if you ever hear a law professor say they'll try to be brief, run. But I really will. There's some overlap between, I think, the presentation to the right and to the left of me, so I'll try to be a little bit briefer to avoid more overlap. I think I want to start out by sort of signposting what has got me thinking today, and it was Tom Holman of ICE talking about how individuals asserting their rights. He was sort of disparagingly speaking about know your rights. He says, they're obstructing our efforts to enforce the law. They call it know your rights.
And I thought to myself, if you are asserting a right, then the person who is violating the law is the person who is violating your rights, right? If you have a right, then the violator is the person who is infringing on it. And that kind of mirror world that he took us into, I think, is a really good starting point for thinking about the role of states and localities in this moment and in general when it comes to immigration, immigration enforcement, and immigrant integration. So we do know that the federal government has primary responsibility for immigration law in the sense that it gets to define who is allowed to immigrate and who can be removed, in the sense that it has the enforcement power to effectuate those choices. That is, choices that Congress makes and that the executive branch has the power to enforce, and that states, at least historically, didn't play a role in that. And so I think one of the possible over-readings of that power is that means states and localities need to do and have to do everything that the federal government or the federal governmental actor like the president demands in a particular moment. And I think it's really important in this time to sort of reassert that that is not the way federalism works, and it's not the way federalism works even in the immigration space. We know from reading DeCanis versus FICA in 1976 that when California had laws governing the employment of unauthorized workers, the Supreme Court was clear that while Congress regulates immigration, states have police powers where they broadly regulate the issues and matters that belong to them. Those are things like employment, those are things like education, those are basic policing choices. That is the area where states and localities have the ability, broad ability, to decide how they want to govern their residents. And it is sort of, they have to be mindful of what federal law is. There is obviously the power of the federal government to preempt state and local choices when the federal government acts explicitly to preempt state and local choices. But it is also when the federal government has not spoken, when there is space under federal laws for states and localities to make choices, they can do that. Moreover, the Supreme Court has been very clear that the federal government can't coerce or commandeer state and local officials to do their work for them, right? So the federal government does have power to try to get and try to encourage and really try to encourage state and local cooperation, including through funding choices. Right, deciding to fund something in order to incentivize states and localities to take particular actions. But what the Supreme Court has been clear in cases like Prince about is the fact that they can't make state and local government actors do things for them just because they want to. And certainly in the absence of congressional action, it's not up to the president to decide to mandate states and localities and state and local actors to do stuff for him. And I just think it's worth, all of you know this, right? You've studied con law, you've had to listen to your con law professor drone on and on about these things, but I do think it's worth highlighting these things in this moment, because there is a way in which some of the rhetoric around state and local compliance it turns these things on their head and suggests that when states and localities are trying to make choices about the best way to use their resources or trying to make choices about the best way to ensure the safety and prosperity and happiness of their residents, that this is somehow illegal because an executive order has rolled down. And I think it's really important for us to sort of hold on to the basic principles of constitutional law, including the space that gives to states and localities to act in this time. And what I wanted to do with the sort of balance of my time is to just think about 6 different, and I'll be very brief about each, sort of 6 different spaces in between where the federal law requires certain things or preempts certain things, and where states and localities have room to act. That I think are sort of relevant to this conversation about criminalized migrants and enforcement. So one, and Stacey's already alluded to this, is sort of the development and changes to their own substantive and procedural regulations of the criminal law. What do we criminalize? What do we decide is a crime? Who are we deciding to prosecute as a criminal? And then what are the sorts of procedural protections that are put into place for them, both in terms of their rights pending conviction and also post-conviction relief, right? The habeas challenges or even post-release challenges, which California has sort of creative space around. So that's one space where states and localities have the power to act, and they can act in ways that broadly help communities, and I don't just mean immigrant communities or communities of people who lack citizenship, but broadly help communities by decriminalizing or decreasing the repressive force of the criminal law in ways that align with their values and choices. So that is one space that states and localities have, states in particular in this moment, but also localities who have municipal ordinances, et cetera, that might criminalize people, where there's nothing in federal immigration law that has anything to say about the kinds of choices that are made there. Another area is around licensing. Who gets a driver's license? Who can sell food on the street, right? These kinds of choices that municipalities can make on a day-to-day basis that influence who can be targeted as criminal and who cannot. So this is like area number 2, where low-level choices by municipalities about what will be a crime and who will be policed as somebody who is violating the law ultimately have the potential to shape who is entering the pipeline for potential removal and who's entering the pipeline, if they're citizens, for potential criminal penalties, right? Again, the sort of benefits of thinking about these leniency in these areas and thinking about generosity with regard to licensing is something that benefits residents broadly and should be part of the thinking in this moment. Record-keeping policies. What information are various state and local entities gathering about people? Right here, again, this sort of aligns with my point about prints. The federal government can't require states and localities to do certain things. That was the whole point of the Prince case, right? Prince was a case about federal firearms laws, and there was as part of the federal firearms law, there was a command to states and localities to, in the interim, before a federal database could be set up, to collect certain kinds of information about gun purchasers. And the Supreme Court said, can't do that, right? You can't make these Montana officials gather information about potential gun owners. That's Prince, right? So unless they're giving money to states and localities to gather certain kinds of information and incentivizing it, they can't just command the collection of certain data as a constitutional matter. So I think it's important then to think about what records do you keep? What records do you collect as a systemic matter? Do you need that information? Is that important to your function, to your job, or is it unnecessary? So that's another space. Arrest power and policing. This is another this is kind of a place where local choices matter, right? How do we want our police to work in the streets? When do we want them to exercise the discretion to arrest? And how do we cabin and curtail the arrest power if we think it's being used overly broadly or too aggressively? That is not a question of federal immigration law. That is a question of state and local law. It's a question over which local actors have power. They can exercise that power in good ways and bad, right? Or more aggressive or less, right? Those are choices that people can make. But I think it's important to note that this is both relevant to the way that people might be flagged for potential immigration enforcement and completely detached from the federal government's immigration powers. So that's another space. And then I think, because I don't want to take up too much time, I want to sort of end on a positive note, but thinking about integrative policies, right? The many spaces where states and state governments in particular, and also local actors can make choices about whom to include in education policies, in healthcare policies, in labor protections, in all of these things that, again, the court has been very clear about are not immigration law, but are about how states with their sovereign powers govern their residents. Now, at the end of the day, all of these things are choices, right, that states and localities can make. And I want to sort of reference back to Professor Kaplow's map. Different states and different localities will exercise those powers differently. One of the consequences of this is that immigration status will affect how people experience life in the United States, but so will where they live in the United States. So people are going to have very different experiences that are tied to their immigration status as a consequence of the very different ways that states and localities are choosing to make these sets of choices. And I think it's important to flag out the ways in which we don't really have a sort of a homogeneous experience. And the other thing to flag is that those maps kind of align with state boundaries. But the empirical research that I did in Southern California revealed the way in which even within jurisdictions where a state says they're immigrant protective, choices made by county governments, including sheriffs, choices made by local police, choices made by local education officials, still impact people, sometimes in ways that are at odds with law that the states have passed. And the reverse is also true. So jurisdictions like Austin have butted heads with restrictive state laws in places like Texas. So it's a complicated picture, which means it's very complicated to be out of status in the United States right now. And I think we need to keep those complexities in our mind front and center when we're thinking about the experiences that people are having, and also when we're thinking about how we're advising people who are moving through the world on this very, very uneven terrain. And so I think I'll close there, but happy to chat more about any of this.
Okay, Jennifer, so a curveball based on, I think it was your fourth point, your reference to prints and commandeering.
Yeah.
So let's talk about the 10th Amendment. Okay. And also a topic that probably many people in the room wonder about, and it's sanctuary jurisdictions. So, I've always argued that in part of the argument that I've advanced is that sanctuary jurisdictions are safe in part because the federal government can't commandeer their services to do the work for them. And I know sanctuary ordinances vary from jurisdiction to jurisdiction, but do you agree that conceptually sanctuary ordinances of non-cooperation are safe?
So I think I would answer that, I never want to give a straight answer because I'm a lawyer. I guess I would say, I think, as you said, sanctuary ordinances differ. And so there's a great article about this, by the way, by Ingrid Egley, Annie Lai, and a number of other scholars who collaborated on sort of typologies of sanctuaries. So it's not all one thing. And so if you're sort of interested in seeing the way they break down different ways that different jurisdictions have tried to draft various kinds of non-cooperation ordinances, this is a good way to sort of dig into that. But I think the answer would be, to the extent you are not doing something that violates 8 U.S.C. Section 1373, which I think most of these sanctuary ordinances don't, then you should be on solid ground, right? You are not violating any federal laws. You are making decisions about your own police power, about the exercise of the rest powers, about information gathering, et cetera.
Public safety.
Public safety. The one sort of litigation hook that I think has been successful in challenging ordinances such as these is can the federal government use some of the law enforcement grants that it uses in order to, say, if you don't do these things for us, we will take away your burn grants, for example, right, which are, heavily subsidizing state and local policing. And here the law is sort of split, there's Ninth Circuit law, which is actually pretty favorable to state and local jurisdictions, so where we are. There's Second Circuit law that's less favorable in that regard. So I think there's sort of an open question about, when you are using funding as a tool, there are certain requirements that have to be met, as the 10th Amendment case law tells us. But I think sort of figuring out, is law enforcement funding germane enough to the issues at hand that the federal government can pull that funding in order to require certain state and local actions? Those are questions that we're going to be seeing litigated in the months to come.
And we'll see whether or not he's got so much control over Congress that they will add those funding conditions to new grants. Francisco, first I'm going to hand this down to you.
Thank you.
So Francisco, I think you're going to talk not just about how your office at the Public Defenders will or has responded to Trump-esque types of efforts, but you have experience in the community as well. And you were there when the first rapid response, well, I don't know if it was the first, but when Rapid Response Network was set up in San Francisco. Tell us what you are thinking.
I am that old, but is this?
Let's just this one.
Yeah, this is better.
There we go. Can people hear me? Yeah. Well, I'm still kind of blown away by my co-panelists. I found myself taking notes of many of the things they were offering. And I was part of one of the first rapid response systems here in San Francisco. And I do, just before I get into that, I want to comment that as our panelists were talking about different ways localities and states have responded, a larger concept of democratic solutions and local democratic solutions was popping in my head. And we think about democracy, or we think about immigration enforcement in many different ways. I sometimes hear kind of enforcement-heavy talking points like, if someone comes into your yard, you have the right to get that person out of your property, right? And I've always wondered, well, who speaks for that property? And what if the people who speak for that property want to welcome people and then other people want to expel those people? Then we have a crisis, and I think we're seeing the reflection of that crisis today. Because we are somewhat being gaslit right now to think, well, mass deportation is super popular. We want to just throw everybody out, when in reality, if you look at virtually most major cities in the country, certainly San Francisco, California, and even the history of our immigration laws, we've had these very proactive, welcoming policies. JRAD, judicial recommendation against deportation, that's a criminal court judge adjudicating crimes who's responsible for public safety in the community, saying, okay, well, I understand this happened, but we're not going to let you get deported because we understand there's an opportunity for rehabilitation. Congress stripped that. There are different, I love the idea of a state-sponsored visa, but really what that involves is community, democratically elected leaders recognizing the importance of people born outside the country to be part of that community. And I think that's really can be lost in this dialogue. So it's something that I'm very passionate about. And I'm going to talk a little bit about this time and how we can respond to what I believe to be attacks on fundamental democracy and fundamental human rights. And I think it's important for all of us. It's a true honor to be here with everyone. There's a lot of brilliance in this room, and I hope that I can help contribute to the dialogue. But I do think that we have a responsibility to stand up for foundational principles, whether this is pure rationality or neutrality, evidence-based decision-making. Our country is predicated on the Bill of Rights. We don't want roving federal agents coming in, patrolling our neighborhoods, taking people away without due process of law. These are things that are all under attack now. I'm proud to work at the San Francisco Public Defender's Office. In 2016, the city and county came together to, in a similar time that we're living in right now, under a threat of mass deportation, the city said we want to invest in deportation defense. We want to invest in access to counsel, because the vast majority of deportations happen in the United States where a person waives their claims to relief and never actually speaks to a lawyer. That is still the case today. So the concept is, well, let's make sure people at least have an opportunity to have a claim. So we built a unit. We also supported a doubling of investment in legal services for immigrants in San Francisco to nonprofit providers. And I think in this city is a pretty remarkable example of what can happen when the community comes together to protect immigrants. So let's see. So this is our office. San Francisco has an elected public defender, one of the only places I think the only place in California with an elected public defender. And as a result, there's less worry that if he does something wrong, that the mayor can fire him. So It's a lot of power, and we have a kind of a wraparound approach. So we, in terms of we see ourselves as much as defense lawyers as we are as counselors. We even consider ourselves public safety officers, because if a person accused of a crime, oftentimes that person is not very proud of what they've done. They want to figure out a way to integrate into the community, and our job not only is to help that person avoid the punishing consequences of crime, but it's also to work with that person. Maybe that person needs housing, maybe the person has a drug addiction. What can we do to help that person make a better decision the next time? And if you look at where our immigration system is right now, it's deeply interconnected to the criminal justice system. And so we kind of have a philosophy that deportation defense is public defense. That we think of, okay, public defenders, we represent people in criminal courts. Well, there is a massive number of people facing incarceration, permanent consequences, and go figure the government doesn't give appointed counsel. We want to change that narrative. We want to say everyone facing deportation has a right to a lawyer and should be able to make a claim. Deportation defense is public defense, and I have a little slide of what we do. We have 7 lawyers, 5 support staff. We also provide written consultations to every criminal defense attorney if they're representing a client accused of a crime and they're a non-citizen. We provide written advice as to how to avoid conviction that triggers automatic immigration consequences, and we also represent those people in removal proceedings if they're facing deportation. So I wanted to talk a little bit about what we're seeing today. Threats of mass deportation, threats of mass detention. And I think it's important to take a step back and to realize that we can actually resist this quite effectively. We have a lot of power. We're kind of being, I said the word gaslight, but I'm going to say it again. Like, they want to strip away this concept that, well, we don't have to do this. We don't have to participate if we don't want to in mass deportation. And if you look if you look at the media, New York Times is not considered like necessarily a right-wing or heavily favoring deportation. But if you look at their headlines, so often it's like these terrifying headlines: mass deportation. Oh my gosh, what's going on? And very rarely do you see a headline that talks about the successes of immigrants, or like the remarkable stories of the localities that are building power, or the unity and solidarity of people. Instead, it seems like it's just a mantra of how horrible things are and how the federal government is just going to disrupt everything. So we just had a staff meeting recently, and I introduced myself as having changed my name to Power Not Panic. So that is my mantra. I say it regularly, all the time: power not panic. We're kind of panicking now, and it's important to get out of that. People are talking about mass deportation, but what we're not talking about is the plethora of laws that exist today that immigrants can avail themselves of to avoid deportation. Just early this week, I had a decision in one of my cases. A person who and I have permission to tell this story, was arrested last year by immigration cooperating with a parole agent. And this person had fled Honduras. The person had actually been deported in 2012 after trying to fight their case on their own in Arizona. He had been arrested in San Francisco, transferred to Arizona. He lost. He got deported to Honduras, and in Honduras, within 3 weeks, he was virtually killed by gangs in Honduras. So he hid, fled again, got back to San Francisco somehow, no idea how, but he got here. And then he started working, and then things went poorly. Things are very expensive here. And so he started living in the Tenderloin, started using, and actually started selling to keep his habit. We've heard all these stories. And then he picked up another case, ended up going to prison, was released, and on parole. He was found to lack credibility in his prior proceeding. And So that was the case that I found when I met him in immigration detention. It took a year. We had a very hard judge. But we won the case. We won a case for deferral for removal under the Convention Against Torture. And it's just a reminder that this was one of the hardest cases I've seen in my career. And it's possible to win these cases. We can win these cases. And just from a removal defense attorney, everything's so doom and gloom. And that's just one story of so many cases from our office, and we work in, with extraordinary nonprofits who win miracles every day. I tend to think that our struggle around deportation and enforcement is a way, excuse the rhetoric here, but it's a way to distract us from real issues relating to immigrants, which is the reality that we as a country invite immigrants to come work very difficult jobs, exploit immigrant labor, and immigrant workers don't get the value of the profit they create. And so instead of fighting for fundamental human dignity and for immigrants to be able to work with citizens to come together, build solidarity, and build a society that is less unequal than it is. Here we are spending all of our time talking about whether somebody should be deported or not, who's lived here 20 years. And it's, in some ways, I've been doing some interviews recently and talking on this panel, and it's like, whenever I'm talking a lot, it usually means there's a really bad crisis happening. And it's like, ideally we need to organize ourselves out of a job. But so I want to talk a little bit. There's also this concept that, we're being flooded with immigrants. There's so many people here, and what are we going to do? And if you look at the per capita number of people born in different countries, it's pretty much has been the same over the last 100, 120 years. It's just important to have a fact-based conversation on these issues. It's also important to understand mass deportation is not something that's always happened in this country. It's a relatively new phenomenon. Now, in the 50s, there was a Bracero program, but if you look at some of this chart, over about a 120-year period, this country averaged about 20,000 deportations a year. I've spoken with immigration lawyers who practiced in the 80s who said, well, in detained court, there may have been 1 or 2 detained cases each week. It's the 1996 IRCA, September 11th, where we saw just an explosion of investment in a deportation structure. We see more recently, the numbers under President Obama, as everybody probably knows, were the highest we've seen in this country's history. The numbers went down under Biden, but that's also a result of the pandemic. The other thing that I think is really important on the deportation statistics, these are just statistics that I compiled looking at ICE data. 92% of the 3 million people that have been deported from this country since 1996 come from one of 4 countries: Guatemala, El Salvador, Honduras, or Mexico. And so clearly there's a disparate impact. You can draw whatever conclusions you want, but there's a disparate impact happening. Most of the people deported when we saw huge collusion between police and ICE. Most people have lived here 10 years. 50% or more had U.S. citizen children. So these are members of our community, critical members of our community. I'm just going to move on here. Just in terms of the panic, just remember ICE is an agency. There are 6,000 deportation officers in the country. By analogy, there are about 2,000 police officers in San Francisco. I think the Los Angeles Police Department has about 9,000 police officers. Many people in the community are absolutely terrified right now, but they can't be everywhere all at once. They're creating this impression that they are, but there's no way they can be there. So again, it's important for us to relax, have work, build our power. There was some conversations about sanctuary. There's a lot of antagonism around sanctuary, a lot of criticism, but one thing that we do know, and there have been so many studies of sanctuary ordinances and what happens when police collaborate with immigration, and whether that promotes public safety. Well, whether it's a right-wing study, left-wing, there's really no correlation. There's no data suggesting that increased deportation rates actually improve public safety. If anything, the studies suggest that electing not to participate in deportation efforts improves public safety because victims of crimes tend to be more willing to report crimes to the police. So, what's the takeaway? In my experience, mass deportations are awful and they're ugly and horrible, but they also lead to movements of resistance, of solidarity, of coming together. And we saw that under the Trump administration, you know, the threats of building the wall, who would pay for it, Mexico, threats to take away TPS, threats to take away DACA. We came together and we fought back. So in some ways, this is an opportunity for people on the immigrant rights movement to build up power. And our networks have never been stronger. We have never had more deportation defenders on the ground than we do today. And yeah, I think that's it. What can you do? I'll leave this slide up as certain things that, you know, steps people take if you're passionate about these issues, getting involved, having a house party, like talking about these issues with folks, just building a model of communication, education, making sure there's a phone number, ICE Rapid Response Network. There's a 24-hour number in San Francisco if somebody's picked up by ICE. There will be an immediate attorney response. Unfortunately, that number has been called a lot this week. There have been many, many arrests. And I know people in this room are working on that. So anyhow, that's what I'd like to say, and thank you for being here.
Thank you, Francisco. Yeah, we're all privileged to be part of the Defense Collaborative, and it is impressive, but I'm sure you will agree that it's still not enough, that so many people continue to be unrepresented. So, I don't want you to get into the details of Laken Riley, but, you know, when it passed, you must have had flashbacks, and I'll explain to the audience, legislation that was proposed after the killing of
Catherine Stanley.
Yeah. Because you represented you and Matt Gonzalez got an acquittal of first-degree charges of the shooting of Kate Stanley. And I guess the legislation that was proposed then and Lincoln Riley now, what's your, I guess I want to know really what your gut reaction was to the passing of that legislation and how it caused a flashback. And you're representing, I guess you know him as Pepe, representation of Pepe, the defendant in that case.
My gut reaction is that we have a catastrophic failure of our democracy. That's what my reflection, what my honest, and that the Democratic Party was completely foundationally unable to respond to a relatively easy talking point, which is taking one crime and then attributing immigration status to the culpability of the crime. And therefore the solution is to make this sweeping determination that anyone arrested on a shoplifting or theft offense, arrested, if they are ever detained by ICE, innocent of the charge, they cannot go to a judge and prove that they're not a danger to the community or a flight risk. It is so irrational, this law, And it is so embarrassing in some ways to our national dialogue that we are unable to grasp how absurd that solution is. How even, I mean, any evidentiary evaluation of that case, okay, well, anybody arrested on a theft offense? I mean, I had a prosecutor calling me saying, well, you know, people who are arrested for theft usually don't commit murder. If you wanted to do that, you may want to look at these other crimes that were more, but it's just, it's truly shocking. And I think we have a lot of work to do. It's pretty awful that many people in the Democratic Party who think is more pro-immigrant, but evidence suggests actually, Democrats have been as culpable in our enforcement regime as Republicans. So it's, but then you have to realize, you have to believe, my second gut, every action has a reaction. This irrationality will be exposed. People will realize how flawed this will be. And so we'll have to correct that. So that's what my hope is.
Thank you. Let me open it up to some questions or comments from the audience. Anyone out there? Is there a sign of life?
Thank you. I always ask a question. Thank you for this amazing panel, and thank you for asking about Life and Riley. I was very curious about that. I'm curious about sanctuary, but specifically where sanctuary ordinances and statements may conflict or have gaps between the federal, state, county, local, district, school district, or school level where some of us work. Specifically where there might be gaps in litigation between one group and another, and people are standing forth to protect their own or others. What protections can be created in the meantime when those gaps exist?
What kind of gap do you have in mind, Jane?
So I'm wondering, for example, so we work with school districts. If school districts were not to enforce or support the sanctuary ordinances of the state and were to let ICE or other folks into their campuses and not protect their students, and a teacher perhaps stood up to protect a student, what protections would that teacher have? Does that make sense?
Specific question. Yeah, I mean, I have a reaction, but you guys go ahead.
Yeah, I think there is always room to strengthen sanctuary. I mean, there are certain things that is impossible to do, so a state and locality can't legislate the conduct of the federal government in certain ways, but to have policies around who can be present, who's not, and to have maybe also to have trainings on what to happen if an immigration officer enters a school district or something like that, and to have a plan in place, make sure people know like there should be a designated person to be able to understand how to interact. That person doesn't have a warrant and they're not there, then they can be, they can be asked to leave. So there are different ways. I don't know if other people,
if you have any other.
Yeah, I mean, I guess.
Here, go ahead.
Oh, right.
Grab that.
Right, I have the bad one. I mean, I think we have seen this play out for a long time, where perhaps a sheriff's office is involved in communications that seem to be prohibited by state law. So this is not an uncommon happening. So, I think state officials can become involved in this through investigations. You can find out whether particular entities are not complying with the requirements of state law. But I think you're sort of flagging a bigger problem, which is the vulnerability of individual employees who might be trying to comply with state law when they're working within a system or agency or organization that doesn't seem to be compliant. Are there specific legal protections for them? And presumably if they're acting pursuant to state law, have the protection of acting pursuant to state law, but that's not a huge comfort to people in the moment that their organization is sort of confronting them. And so I think, maybe part of this is building networks of support, but also definitely flagging for state officials and inspectors that, that there's not compliance among entities or organizations with state law principles. But
right. Let me add to the discomfort, okay? You're not going to like these answers.
Yeah, they're not great answers.
If I understand your question correctly, Jane, and let me repeat what I thought you heard. What I thought I heard was that an ICE officer comes into a school and the school doesn't comply, the school cooperates with ICE and lets the person in, and a teacher wants to protect that student, okay? That's what I heard. First of all, it probably is a violation of the State Values Act, because in the State Values Act, you're not supposed to provide use any public services, any public, what's the term I'm looking, resources to enforce immigration laws. But one problem is that there's no sanction for violation of that. In San Francisco, which has a very strong sanctuary ordinance, if a police officer cooperates in violation of the sanctuary ordinance, all the police department can do is possibly put that person on probation. Definitely not fired, okay? And so there's really not much oomph behind, enforcement behind that. Secondly, for that individual, and I'm assuming they come in without a warrant, okay? That individual who stands up to protect someone, it kind of depends on what you mean by protect. And if that person, if the teacher knows that that person is undocumented, I would worry. I would worry about a prosecution for harboring if the person actually knew that that child was undocumented. I could see a Trump U.S. attorney for sure investigating and possibly bringing an action.
Can I follow up?
Yeah, go ahead, Francisco, go.
I just want to follow up on the harboring question, because that is going to happen. The U.S. Attorney is investigating localities on harboring sanctuary. We saw that happen in 2008 in San Francisco, where there was a threat. There was a grand jury investigation against probation officers who were transporting undocumented people, and the Obama election kind of stopped that investigation. So we will see harboring prosecutions, but there are very easy ways to avoid harboring, and I think at some point we can, make sure we train people. What is an effective execution of or claiming your Fifth Amendment right, and what is not legal? So, I just remember Mark Silverman always talking about you can't run. Don't advise anybody to run if they come to your workplace, but if you run fast. So that's a joke.
Are you okay, Jane?
Yeah, can I do a quick follow-up? Is there a role for the California AG in this, and to protect against possible prosecutions? I'm working on an advocacy strategy.
To protect against prosecution, I'm not sure, but I mean, they can help get an injunction against improper ICE actions that violate the Fourth Amendment. I mean, generally, okay, they can get an injunction against Fourth Amendment violations. But in terms of protecting the person who may or may not be guilty of harboring, I don't think so.
Yeah, I mean, I think you would want to be familiar with the harboring law and potential risks there, and just general obstruction kinds of claims that could be brought, and just make sure that the conduct that people are engaging in is not running afoul to the extent possible of those provisions. There are laws, and I think this administration is committed to enforce, certainly pursuing aggressive prosecution strategies, and so it is important for people to be really careful to make sure that they're, if they want to be engaged in civil disobedience, then that's fine, but they should be aware that they are engaging in civil disobedience and that there are potential penalties for doing that.
Right, I'm not going to end on a high note. I'm going to make it worse, and because it wasn't exactly harboring, but two names that I'll throw out there that relate to Texas are Jack Elder and Stacy Merkt, M-E-R-K-T, okay? They were prosecuted for illegal transportation under the Reagan administration within the state of Texas, not across the border. They were prosecuted. Jack Elder went to prison for transporting an asylum applicant to an asylum office to apply for asylum. And on his drive, he passed by an immigration office that he knew was not that friendly. So he went to another immigration office to help that person apply for asylum. He was convicted of transportation. Okay, that's the end of the panel. 15-minute break.
Up to the stage to introduce our final keynote speaker.
Thanks, everyone. Thank you for staying. It's going to be well worth your patience because of our keynote speaker. So Gaby is the president of and CEO of Dream US, and she gained, somebody alluded to this earlier, but she gained national recognition in 2004 for her courageous advocacy of the DREAM Act and immigration reform. And in 2005, she led a Florida-based immigrant youth group advocating for in-state tuition for undocumented students. In 2010, she led a group of students on the Trail of Dreams, a 4-month walk from Miami to Washington, D.C., to call attention to the plight of immigrant families under the threat of deportation. In 2012, as the political director for United We Dream, she spearheaded the effort that led to the implementation of DACA by putting pressure on the president himself. She's an immigrant from Ecuador, and in 2013, she became the first undocumented Latina to testify in front of Congress, speaking to the Senate Judiciary Committee about the urgent need for immigration reform. And a few years ago, she got an honorary doctorate in humanities from the New School. But this is my favorite, Gaby, and I scoured the internet for this, but I couldn't find it. She was profiled in Elle magazine alongside other illustrious people like America Ferrara, Olivia Wilde, and Anna Kendrick. And if you can find that photo, it is cool. And so that's a teaser. And she was also the recipient of the Flo Burton Award for the Immigrant Legal Resource Center a few years ago. So please join me in welcoming Gaby Pacheco.
Bill, you don't know how hard that was. I gained so much respect for models after that. We had to be there at 3 in the morning. They changed my hair 3 times because the photographer didn't like it. And I was on top of this rock in Central Park, and the photographer was screaming at me saying, "Give me more, Gaby, give me more." And I'm like, "More what?" So yes, well, it's just so incredible to be here. I wouldn't want to be anywhere else. And I'm just so privileged that over a year ago, Bill had, I don't know if it's a foresight, I wish he would have told me what was going to be happening, but he asked me if I would be willing to come and speak here. And I said yes. And then I forgot that I had said yes. And then I started receiving emails from this Kenji guy, and very persistent, telling me, "Are you ready? Are you ready?" Until somebody on LinkedIn says, "Oh, I can't wait to see you." And I'm like, "Oh my gosh, I need to book a flight and go to San Francisco." But so happy to be here, and I just want to start with an exercise. And you can close your eyes or just gaze. But I want you to just put yourself in your home, where you live. And I want you to look out the window and look at your neighbor's home. And the sun has not come out. It's still dark. You might perhaps be making your coffee. And you start to see some activities in your neighbor's home. And you're witnessing these people with bulletproof vests knocking on the door of your neighbors.
and your neighbor opens that door, and 15 minutes later, you see the mom and the dad being taken out. They're handcuffed. You see the oldest of the family being taken out. He's also handcuffed. And then you see the little one who is being taken by the Child Protective Services, and she's crying, not understanding what is happening to her family. This is happening all across the country right now. It's been happening all across the country for decades. And you now have to make the decision of what do you do? How do you respond to that? So now I want you to come back into this room. And if I may, I want to share with you a little bit about my personal story and how I got here. I'm originally from Guayaquil, Ecuador, a little place in Mexico. Just kidding. You don't know how many times I have been asked, what part of Mexico is that in? But Ecuador is a very small, tiny country in South America. I'd actually be so proud to be from Mexico, by the way, just saying, it is my third country. And I came to the United States following my parents. My two older sisters were already here. One of them had been begging my mom for years to let her move to the United States to come learn English. So she already had been here living with an aunt. The other sister also had come to the United States because my parents brought her to the United States to see an ear specialist. She needed special surgery that wasn't available in Ecuador, and so they came to Miami, Florida to have my sister have these surgeries. And in one of those trips, my dad saw something that he wanted for his children. It was these elementary school kids walking together from their home to school. And he thought, I want that for my children. So after all these different events happened in Ecuador, my family just didn't feel safe, and they thought, we're gonna move to the United States. So they moved to the United States. They hired an attorney. They took us, the 4 children, to the local school, and they processed international student visas for us. And my parents started working with an immigration attorney to try to figure out if they can either get a B visa, whatever it was, right, to be able to stay in the country legally while their B visas, their tourist visa, right, to not stay here without status. But one thing led to the other. And all I could remember as a child was my dad always asking my older sister to call Texas. Texas was the key word for the service center where our paperwork was in. And she was the one that could call and translate and try to figure out where our paperwork, what was happening. Because every single time we talked to the immigration attorney, we would talk to a paralegal, and they would say, oh, we're just waiting on immigration, et cetera, et cetera. So it was in the 8th grade when my sister comes home crying because my mom had taken her to the local community college, and they had told her that because she didn't have the right kind of papers, she couldn't be admitted. And she was so mad at my mom telling her all these things that I didn't quite understand. But it was then that I realized if she cannot go to school to be a nurse, and they keep telling us, and I see in the news and I hear that there's a critical shortage of nurses, and my sister, this person wants to study to be a nurse, but they're telling her that she can't. Oh, like, I'm not going to be able to go to school either. And I want to be a meteorologist. And then I said, but I have an idea. I have heard that if you join the military, you can get your papers. How many people have heard that? Right. So there was an ex-sister. We had these Army recruiters at our home sitting around our table, talking to my parents, trying to recruit my sister. And when it got to the immigration question, their faces dropped and they said, oh, we can't recruit your daughter because she doesn't have papers. She has a social security number, but not papers. And there I thought, oh no, not even the military wants us? And so it was when I graduated high school that I started having people reach out to me because I was a very loud mouth. And I, as a 17, 18-year-old, didn't quite understand why no adult could help us. And I would tell people, I don't have papers. And I would tell my counselors and the teachers, and everybody just went like, oh, right, the little emoji. And I started having friends come up to me and ask me to pinky promise and put me in a corner and tell me, Gabby, I also don't have papers. And if you figure out a way to go to college, please let me know. So I was a very persistent child, and I was able to convince the woman who in the 3rd grade processed our student visa to help me convince immigration to reissue my international student visa that I had lost going from the 5th grade to the 6th grade. And for those immigration attorneys here, they're kind of scratching their heads and like, what? So I had duration status, and because of that, and I was very convincing, I was able to actually get into Miami College. But my process was so hard and difficult. How do I tell that to my friends? How do I explain that to them that I got in and they didn't? How can I face my sisters and tell them I figured it out? And for some way, some reason, I was considered worthy enough to go to college, but not them. And that's where my advocacy started, with just a desire to go to college. And so I started learning about the issue. I stumbled upon the DREAM Act. I became a subject expert. I was being flown across the country. And in 2006, early in the morning, before the sun came out, there was a knock at our door. And the police with ICE were there looking for me. And so when they knocked on the door, my sister, who was always the first one out, opened the door, and the police convincingly told her, we're just here to make sure that everything's okay. We're looking for a fugitive named Maria Pacheco. Can we see your ID? So as soon as she opened the door, she let them in. Next thing I knew, I was sleeping, and my sister's asking me to wake up, and she's saying, Gabby, Gabby, the police are here and they want to see your ID. And the first thing I thought was, oh crap, did I put clothes on last night? I quickly checked and I was like, thank God. And I opened my eyes to a police officer telling me, get up. So they rounded us in the middle of our home, and I was really confused. I didn't understand what was happening. They were looking at all of our IDs, and they were looking for the Maria Pachecos. Well, guess what? If you are in an immigrant family, there's tons of Maria Pachecos. There's Maria Gabriela Pacheco, there's Maria de Fatima Pacheco, my sister, there's Erika Maria Pacheco, my other sister, and there's Maria de Fatima Pacheco, my mom. And ICE wasn't really sure which Maria Pacheco they wanted, so they took them all. And so they took my parents and my sisters. But as they were taking me, I asked my sister, should I stay or should I go? Because I knew my rights, and I knew that they didn't have a warrant, and I actually had an immigration status. I had a student visa. So why should I go with them? So I was able to convince them to not take me because they actually thought they had me. My other sister, who looks just like me, they thought, we have the person we're looking for, we're gonna take it. You can stay. Long story short, they put my whole entire family in deportation proceeding. They negotiated with me, and they did ask me to go and present myself, turn myself in, and I did, to be able to get my family out of there because I felt extremely guilty of what was happening in the situation that I put my family, because I was an advocate and activist, and I realized then when they called my sister just saying, you better tell your sister to come here, and you better tell your sister that you should thank her for what is happening to you all. And so when I showed up, they were processing me. They were trying to tell me that I had violated my student visa. They, said all this stuff, and as I was making copies, because right before going there, I went in and made copies of all of the stuff that we had before giving it to them. I don't know how, but I memorized a section of the law. And I cited to them and I said, section 2, blah, 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 says, and he laughed at me. And he said, we are the law. We make the law. So after negotiating with him and saying and promising that I was not going to speak to the media, that afternoon they released my parents and my sisters. I did put my fingers like this behind my back and advocated for that. There was a long case, Ira Kirsten, for those of you that know immigration, know who he is. He took on the case and started fighting for my family's, or not for, but fighting against my family's deportation and fighting a selective prosecution case against me and my family. I just want, and I share all this with you, and it's very hard. To relive those moments, but I must do it. Because this is happening to our community and our families. Laws are created and they're changed. They are molded by society, by our values, sometimes by our advocacy, questions being asked, right? How can we change? What are the things that we can do? And leadership. And in immigration law, as many of you know, is discretionary. Many, many times it's discretionary. When you travel on advanced parole, even though you have a document that is, in essence, telling you that you may or may not be allowed back into the country, but you take that risk as a DACA recipient, you know that it is up to the discretion of that officer, that CBP officer, that day that you get, that will allow you into the country or not. It's not a law, it's the discretion of a person. So, when laws are left to interpretation, and there are enforcement priorities that we see from different administrations, we must really think about some of the questions that were being asked even today. Every single time, and I understand it because all of you are lawyers, well not all of you, some of you are about to be lawyers and are studying the law, I kept hearing and I keep seeing people ask, if I'm a teacher, will I get in trouble if I share Know Your Rights with my students? If I'm a priest and I'm at church, will I get in trouble if I say no to an ICE officer entering my church trying to take one of my members? This is the type of questions that we are being asked when we're asking ourselves. And I think it's a reflection of a system that is violating our own human rights. We can't go to church. We can't go to school. We can't give a bribe to somebody. That is violating a law. History repeats itself. And we have heard Martin Luther King Jr. say, injustice anywhere is a threat to justice everywhere. We have been here before. As a human race, as a country. And I just want to say that I came here today because I have hope. I came here today because in 2023, despite everything that was happening with me and my family, I became a citizen of the United States of America. And I proudly, you should have seen me, begging the officer to be the one that got to say the Pledge of Allegiance. And I proudly stood there with other 59, it was 60 of us, immigrants, repeating the Pledge of Allegiance. And my family, who was spared from deportations because we had pretty badass attorneys, are now either all citizens or green card holders. And my nephew, he was one of the trendsetters, who was born here, is now an attorney and working at corporate law, and at 25, making more than our family combined. So, in this moment that we're in will define us. And it's not just going to define folks as lawyers, as students, as advocates, but it's going to define us as people. Francisco, is he still here? No, he probably had to go. Lots of work. He said, they will gaslight you. They will tell you that you're wrong, that the laws demand we remove people from our communities because they violated the law. They will use one mistake, one misstep, as justification for dismantling families, shattering dreams, and deporting hopes. But I know we know better. We know the law is not a weapon to be wield against the vulnerable. It's not a tool to go against people. It's a tool to protect humanity. The law can evolve, and it must evolve. Because our fight isn't just for immigrants, it's for the soul of our nation. It is for the future generations that are going to come after us. And we know that they will try to divide us. I keep hearing it. They'll say, you're an immigration lawyer, stick to that. Or you're a student, what can you do? We know that oppressions doesn't come from one, they don't come for just one group, FYI. They come from all of us. They're coming after LGBTQ community, they're coming after indigenous community, they're coming after the Black community, they're coming after Latino immigrants, etc., etc. And so every single time you hear someone ask, will I get in trouble if I help an immigrant? And I know, I heard what you all were saying, right? The harboring laws and all these different things. But as a non-attorney, I just want you to know that we have collective rights, and we have human rights, and we have power. They're also going to try to isolate you, to make you believe that you're alone, that the weight of this battle is for you to carry all by yourself. But, as we know it, we're not alone. I just want you to just stop and look around, just look around. Look from this side to this side, next to you. Your power is in this room. It is our shared purpose and passion that we all have for the true law for humanity that is going to be taking us and moving us forward. So, here are 3 practical things, right? I'm like an actions kind of person. So what can we do? We're gonna speak up. We're gonna use our voice, we're gonna write, we're gonna advocate, we're gonna fight for the laws that reflect the values we hold dear. When they gaslight you, when they tell you you're wrong, I hope you respond with, I see through the lies and I will not back down. And as Francisco said, I'm going to add this one to my toolbox. Power, not panic. You're going to bear witness. We're going to be present. We're going to document the injustices. Speak the truth when others are too afraid. It is in witnessing the pain and the fear of others that we will find the strength to do that and to act. And we will protect each other. We will build sanctuaries, create spaces where people can feel saved, loved, and protected. Be the shield between the vulnerable and the oppressor. Together, we are going to make our communities unbreakable. And so I'm going to just close with saying that the reality is that this is not going to be easy. Work is usually never easy, right? And it will break your heart. It's breaking mine. And it's going to test your resolve. But in those moments, I want you to remember, why are you here? I want you to remember your neighbors, the families that have nowhere else to turn. I want you to remember the children who wake up every day wondering if their parents will be there when they come back home. And most importantly, I hope you protect your heart. Because the oppressor wants it to be hardened. They want to give you into cynicism, to exhaust you. They're throwing so much at us that I can't keep track. They want to exhaust you and break you down into despair. But we can't let them win. And we know better. We know that a mother who crosses entire oceans and deserts for their children, for the love that they have for their child, isn't breaking a law. She's doing what any one of us would do to keep our loved ones safe. We know that a dreamer who works 2 jobs while going to college isn't committing a crime. They're a reflection of what is best in this country. And we know that this fight isn't just about policy and politics. It's about people. This room is filled with power. It's filled with courage and conviction to push back against the gaslighters, the lies, the oppressors. And we stand on the shoulders of giants, of the civil leaders, of the suffragists, of the labor organizers, and so many others who have refused to give up. And now, guess what? Are you ready for this? It's our turn. It's our turn to hold the baton in our hands. And I know this, and I've seen it. when we work together, when we stick together, there's nothing that we cannot overcome. So I leave you with this question. I feel like I'm, what is that guy from MSNBC? Mark Quinones. What will you do? Will you use your voice to speak for the voiceless? Will you stand for the justice even when the path is hard? And will you protect our collective humanity? Because the fight ahead will not be easy, but it will be worth it. And I promise you with all my heart that as long as we stand together, we will win. Thank you so much for being here, and thank you for what you do. And I don't think it's time for questions, but yeah, there'll be a quick reception after this.
How about another round of applause? Firstly, on behalf of the Board of Editors of the University of San Francisco School of Law, Volume 59 Law Review, we want to thank everyone for their participation in what has become another successful symposium. Many people dedicated their time and thought to ensure that we were able to gather and host such timely discussions today. And from the start of our symposium, all of our speakers were remarkable in their insights and energy. And I'm truly grateful to have learned a lot from all of you. Thank you to Francisco Ugarte, Shaw Drake, Helen Kerwin, Lauren Bartlett, Jacqueline Brown, Stacy Kaplow, Sabrina Rivera, Jennifer Chacon, Jacqueline Kelly Whitmer, and especially Dr. Gaby Pacheco for sharing your time and expertise with us. I think I speak for everyone here when I say that everything was new, refreshing, unique, and insightful. Throughout our today's sessions, we explored migration in many ways. In a national lens, from an international perspective, and even at the intersection of critical issues like human rights and climate change. Our speakers' insights, combined with your questions and thoughtful engagement, fostered meaningful dialogue that highlights our collective commitment to addressing these pressing issues with both urgency and creativity. So thank you to all of our speakers once again. But of course, today would not have been possible without the involvement of Professors Hing and Professor Harris. Our entire journal is very grateful to our faculty advisors for not only agreeing to moderate today, but also serving as teachers, collaborators, mentors, and contributors in countless ways. It's really hard to overstate how easy, effortless, and rewarding it is to work with two individuals so committed to their community, to justice, and to understanding critical legal issues, especially in scholarship. Thank you for being the driving force behind this event. We really mean that. Thank you so much. Moreover, our journal is proud and humbled to enjoy the support of community organizations, incredible community organizations like the Immigrant Legal Resource Center, which provide invaluable resources to our community. Also like to thank the USF School of Law's Immigration and Deportation Defense Clinic, Frank C. Newman International Human Rights Law Clinic, and USF's Masters in Migration Studies program for partnering with us today. As a matter of fact, we'd like to thank everyone in the USF community because whether it's the administration, the faculty, student clubs, people who have been working behind the scenes for this event, the support we receive from all of you makes all of our work that much more rewarding and that much more meaningful. In particular, I'd like to recognize Kenji Keanu. Kenji is the kind of program coordinator whose work often goes unnoticed, but every vital aspect of this event is largely in part due to him. His ability to manage a million moving parts with professionalism and poise is unmatched and very apparent to everyone who works with him. So thank you, Kenji. Of course, thank you to my colleagues in Volume 59, our Board of Editors and staffers for your collaboration, input, and time. And finally, thank you to everyone in attendance for being here and contributing today. Above all, We really hope that you leave here feeling empowered to act. As is very, very apparent, the laws surrounding migration and immigration are not static. They move rapidly, and so too must our response. Every one of us, whether we're in academia, policy, law, or advocacy, has a vital role to play in shaping the future of migration law and ensuring that, at the very least, human dignity is at the center of those conversations. Thank you once again. I invite all of you to continue these great discussions next door at our reception, and thanks again for coming.